been organized.
So we're having some technical sound problems. As soon as the problem is solved, we will begin with the translation. I'm terribly sorry.
This, I am of the community of Bekbokerani of Ayokorka from the Karakara Indigenous Nation. We are Native Americans, indigenous peoples of from Bolivia. So, ladies and brothers and sisters, we will now like to thank in my native language. Please, you can also, according to your own consciousness, you can also request that this event turns out as best as possible. Very well, so here comes my words. First, these are thanks. Thank you very much, ladies and gentlemen. Thank you, brother. We have asked, well, how our forefathers did not understand that the sun, the moon, the mamacocha were our elder brothers, and we had to respect them and thank them for what they were giving us. We've always lived and thanked for everything. It's not only receiving, we have to give thanks also. So these are things that we have forgotten within these days, in this era. In this sense, I ask, please, I urge that all the hard work that we are doing can be applied to with our governments, that they understand that we're trying to do, and they are aware of what we request. As we don't have all our symbolic elements that we need for a ceremony, the sacred fire, the water, wine, to be able to give thanks, we will therefore do something symbolic with these wristbands that we have here, and we will invite 5 people from the audience. It's like a symbol of humanity and commitment, so we can achieve our objectives of today. And when we end the event on the last day, each of us will take with them one of these bracelets, which will be tied to your wrist, so we can all be united, as we're all united in this event. And when we end, each one will untie their bracelet and send it back to their own territory as a symbol of this event. So we request, please, Sara Lopez from the Mexican National Council or Indigenous Council to please come to the stage. Also Carmela Curo from the Maya peoples, Cachiquén in Guatemala. I'm sorry about the pronunciation if I make mistakes. Please, John Derrick, also from Guyana National Council of Tochaos, also. Our narrator, Francisco Cali, if you please, would be honored to come up to stage here. Darlene Garcia from Venezuela, from the Vari peoples, and Mariwa. And I didn't introduce myself. I'm Isabel Godoy Manardes. I'm from the National Council of the Koya Peoples, representative in the process of the constitutional process, where we aspire for a new constitution, hopefully which can include all native peoples of Chile to learn about our rights. We dream about this, but we continue dreaming. Request you if you could unite these, please. Tie them to each other. Do we have Darling here? We will leave it here where our sacred cup is, and when we end, we have the coca leaves there. Each will take with them their bracelet. I'll leave Darlene's wristband here so she can take it with her. And just to thank the respect and the presence and your attendance of all of you in this initiation ceremony. Well, very well, brothers and sisters. We'd like to thank you. We'd like to thank the authorities, the narrator from the United Nations, all judges and magistrates who are part of this region, to our brothers and sisters of our brother nations of the continent, all defenders of the human rights that are here present today. We would like to thank you. In this event, let's hope it turns out as best as possible. Ay, ay. What an inspiring ceremony. Thank you very much, ladies and gentlemen. Let's hope this is an inspirational moment for everyone, like it has been for me. Now, before we begin with dialogues, let me please share some notifications with you. We let you know that the transmission we carried out through our YouTube channel will be broadcasted. You will be able to see everything in the monitors of this hall, and it's important to mention that all activities in this hall will be recorded. The format of dialogue comprises three main blocks here: presentations, networking, and a plenary conference. The last segment is focused on defining action proposals starting from our discussions. Remember to subscribe in one of the three technical work tables available, which are indicated in the blue and yellow and green boards. These will not be transmitted, nevertheless, the workshops. And it's relevant to mention that we have simultaneous interpreting in tables 1 and 2 in English and Portuguese, while in table number 3 we will have everything exclusively in Spanish. We invite you all to attend now the welcoming video of the High Commission for the United Nations on Human Rights. The most important thing is to have a journey onwards. The 75th anniversary for the Universal Declaration of Human Rights is not just an event that is in the calendar. If not, it's a moment for reflection, to act and correct any mistakes of the past, and to reanimate the spirit of this declaration and its promise on human rights for all throughout the world. These regional dialogues will be very useful as a basis for our next declaration on the vision of human rights, which will be carried out publicly in our event in December to commemorate this year of anniversary, and also it will serve as a basis for the summit of the future of next year. Ladies and gentlemen, colleagues, this dialogue will refer to one of the most important issues on human rights within the Americas: access to justice for Native Americans, indigenous peoples. I have had the privilege of gathering and meeting with representatives of indigenous peoples of this part of the world, and to listen directly about their stories. Throughout the region, our office works very strongly with indigenous peoples. They listen to their stories, traditions, ancestral customs, enriching us all. At the same time, we can talk about a whole structural discrimination due to the expansion of the industries, extractive industries, projects of development, the ownership of land and farming, and large-scale farming have usurped the lands of indigenous peoples. These are things that they are facing, even attacks against their lives, simply because they defend their own rights, the land, resources, and territories on which their communities depend on. Nevertheless, facing these severe violations of their human rights, their access to justice is still difficult and complicated in many parts of the continent. Even though access to justice is one of the main principles of rule of law, even though the availability of the Declaration of the United Nations on the rights of indigenous peoples, that indigenous nations have the right to have access to the reparation of all violation of collective and individual human rights, respecting thoroughly their customs, traditions, and legal systems. Dear colleagues, the legal systems and the justice system of each indigenous people are still not recognized by many authorities, whether they be local, international, and regional. Discrimination against indigenous peoples within the legal system is extended, and barriers to seek justice are many. Negative social and economic positions, legal procedures that are inadequate, languages, different languages, fear. We need to seek justice, even the legal insistence, and all companies that deny or ignore their responsibility or accountability of respecting human rights, which makes even more complicated the search for repair for indigenous peoples. There have been progress within this region. Some countries have adopted a legal framework which is dual, where they recognize officially the legal systems of indigenous nations and the authorities of indigenous leaders. We need these laws to truly be put in practice, and we do need that these efforts multiply themselves. We do know that the legal system and indigenous systems, which are indigenous peoples, may play a crucial role at the moment of making access of indigenous nations available to justice, be much closer to the communities they serve. They have stronger rapport with culture and language, a better coordination amongst the legal systems which are indigenous and all ordinary, which can therefore break the barriers currently which do not allow indigenous people to have access to justice. I urge states here to work in collaboration together with indigenous peoples so we can progress towards legal systems that are more comprehensive, especially systems which respond to the needs and specific needs of women, children, and young people, and also people with disability of indigenous peoples. Activists, defenders of human rights of indigenous peoples also require special protection. 5 years ago, the historical agreement of Escazú traced the path so the states of Latin America and the Caribbean can face climate change and will protect the defenders of human rights and the environment. This treaty and agreement guarantees access to justice and also for the defenders of the environment of indigenous peoples to react now in favor of access of indigenous peoples to the justice system and to exercise all their rights and freedom, which is of utmost urgency. I am excited to hear about the commitments which have been carried out here and mentioned here, so this can actually be carried out. And my office is here willing to support you. Thank you very much.
Okay, without further more, to begin the words from opening words, I have the pleasure to invite the main table Ambassador Thomas Pascal, representative from the Ministry of Foreign Affairs from the Chilean Republic, Ms. Maria Jose Torres, Resident Coordinator from the United Nations System in Chile, Mr. John Chiarav, Regional Representative for South America, and my colleague Tina Alvarega, Specialist. Tina, the microphone is yours. Please go ahead. Thank you so much, Pedro. Good morning, everyone. Ladies and gentlemen, let's remember that this regional meeting for America's indigenous people and access to justice that we start today responds to an initiative of the High Commissioner from the United Nations for Human Rights. It is an invitation for a joint reflection on the content of the Universal Declaration for Human Rights after 75 years. The High Commissioner brings us here to renew our commitment and to find new paths to make a reality human rights recognized globally. So now we give the microphone to Mr. Tomás Pascual, Human Rights Director from the Ministry of Foreign Affairs in Chile. Please go ahead. Thank you so much for the invitation. Good morning, all of you, ladies and gentlemen, and those connected virtually. Good morning to the Resident Coordinator, Maria Jose Torres Mato, the representative from the High Commissioner's Office from the United Nations for Human Rights in South America. So to represent the Ministry of Foreign Affairs, today we would like to present our regards and welcome you to our country. It is an honor for us, for the High Commissioner, to have carried out this activity in this place, in this city. And in that sense, we wanted to be present to welcome you to this place. In the framework of 75 years, connected to several commemorative activities that will finish in Geneva in a couple of months, in high-level activity, where we will also be participating, that somehow allows to restate the commitment of each one of the states on the assumptions that were performed back then in this universal commemoration of human rights, and since then has had so far several evolutions from the ratification of several tools, international tools that are binding internationally. The Chilean government has historically worked with the United Nations system. Citizens, men and women of this country, have used the system in difficult times in the past. They continue to use the system currently because we have many challenges to deal with, and it is of extreme importance for international protection systems to use that subsidiary place to protect human rights. We've had the opportunity in this specific administration to reinforce that commitment with different visits from the relatorship that talk about this openness. It is not just to announce the amount of things that we've done, that's not the idea, but for this activity I believe it's worthwhile to visualize that we do have a loyal commitment to the mandate of the state when thinking about the protection of rights of people in collaboration with the United Nations system in Chile. And in that sense, to do echo from the High Commissioner's words about how important it is to generate defense mechanisms for the protection of the advocates of human rights and indigenous people. That is also extremely connected to the territories. We have great challenges regarding the Escazú Agreement and other legal frameworks. We recently have the regional forums of businesses and human rights, and now it's being discussed right now in Geneva, the legally binding tools of transnational companies and different types of companies in the protection of human rights, where we do play a more active type of role. That is what we can offer as a state, a commitment, a real, genuine commitment by identifying the gaps we have and trying to work with the different key players in this topic in order to be loyal to that commitment. Finally, to recognize this moment as an opportunity to listen to those who know more regarding access to justice from indigenous people. The High Commissioner talked about it. We do have key challenges and situations that are obviously that vulnerate people, and we do have key challenges for the Western logic in how we have built the law of integrating legal frameworks of indigenous people to move forward to what Isabel Godoy has talked about a while ago in the opening of dreaming with this to actually be a reality. Thank you so much for being here and for the invitation to present these opening remarks. So we wish for you to have a very successful, fruitful work session to provide light to the states in order to adopt the different elements that are still missing to make a reality the access to justice of indigenous people according to the standards that the international law demands. Thank you. Thank you so much, Mr. Tomás Pascual. Now we ask Ms. María José Torres, resident coordinator from the United Nations Systems in Chile. We give the microphone to her. Good morning. Thank you so much, really. I just wish to welcome you to Santiago, to this event. And as Tomás said, and feeds us with this idea of the High Commissioner, the idea of being together is it's a strong thing, it's a key thing, but the main idea is also to go beyond the conversation, having a concrete proposal. I believe that that is the reason why I celebrate and appreciate the office of the High Commissioner of the United Nations, of course, the Chilean government, for always joining on us from the Chancellery. We know you have a huge commitment with this topic. And if we think about the representation in the room, it indicates what this event wishes to cause. So we have representatives from the legal powers that are truly doing a very important work that promotes the norms of what we have to get to what we can dream about, which is the aspiration, I believe. We have advocates of human rights here that are working every day with the people, from the people, experts on human rights mechanisms. We will speak about Francisco Karen in a while, and of course, leaders, men and women, because without you this type of work would be very difficult to perform. So you are feeding with your testimony, with your work, with your lives, that somehow this system, based on international mechanisms for the rights subscribed by the states, can take another step, which is what we're talking about. So I think that to start, we require to talk about that there's a history on why we're here, speaking about these topics. It is a genocide, oppression system, injustice that have suffered as indigenous people in America since the conquering time. So we're talking about 10 years, 20 years, many years. And that discrimination, that violence, that lack of visibilization and marginalization has had different contexts depending on the moment where each country is, each association, each society, generating obstacles and real barriers for the execution of human rights from all of you, as indigenous people. Something that is extremely interesting, which I believe is a more contemporary type of development, and definitely the United Nations, also as a part of the international system of human rights, has done a specific emphasis. It is not the same speaking about indigenous people rights, that's speaking about indigenous people's rights and women's rights. because we do have a specific situation that we need to visualize, or the issue of children and adolescents, or the issue of indigenous people with disabilities. I do believe that we have an interesting, important attachment for our dual legal system. There's something very interesting that happened this year in Chile. We had the visit from the Deputy Secretary, the General Deputy Secretary, Ms. Mina Mohamed from the United Nations. What she wanted to do in Chile, apart from meeting with the whole team from the United Nations, the senior one for Latin America, for Americas, was having a work session with indigenous people. I think that one of the colleagues that was more in this conversation with the General Deputy Secretary, and she truly left all coordinators, the resident coordinators. We are 23 in the region, men and women, and I'm sure you work a lot with them, and if you still don't, I invite you to do so. Sorry. One of the most important things that happened back then in that dialogue is how our second organization invited indigenous women to be part of that momentum of dialogue, of decision making, thinking about leadership. Because sometimes they, as leaders, are not as visible. So I really like seeing so many women in this space. And I think it's important because we have 75 years since the Universal Declaration of Human Rights, and we have to say we have moved forward in something, and we have. But I do think it's important to talk about what are the remaining challenges. We've also advanced in the application of 169 ILO Convention in these human rights meetings with businesses. That is also one of the topics that it was difficult that exists in this aspect of the work we have as United Nations. But I do believe that we can announce many advances, but we need to continue to recognize that there are many challenges in the future. Therefore, one of the most interesting things that are happening with what we have been saying as United Nations team in the country, as I said, we have 23 teams working on each one of the countries where you come from, and they do have the responsibility of working with the country that sponsors us. We do have a team of countries, Chile with their agenda and programs, and we work in a cooperation framework, an agreement between countries, the United Nations system, and the governments. But that agreement must have a series of requirements in order to have minimum standards. So first thing, an analysis, independent analysis of the current situation of the country, and what we've done as a United Nations team and a coordination team in the region is to analyze for this event how the different cooperation frameworks reflect the analysis of the situation with indigenous peoples and their countries. And I need to say that in all cases there's a reference on this analysis. 80% of our frameworks for cooperation include programmatic work, legal normative work, and dialogue spaces with the indigenous people. So I do want to recognize that I've been working in the region for many years with the United Nations, and I believe there has been a huge twist. That doesn't mean that we don't have to continue to work for things to be different, and that more and more the issue of indigenous people and the work on how to assure that not only you can be part of the analysis, but you can be part of the table to be part of this analysis as a country, which I believe is the main change that these new cooperation frameworks invite us to. It is an exercise, a systematic exercise that we need to carry out to improve the quality of not only the analysis, but for you to be part of the table, part of the solutions that we're working on. And I believe that, and the High Commissioner said it, has been said by Tomas, we have the Escazú Agreement example that truly generates a very interesting space. It is perfectly reflected in our programmatic framework as a country team in Chile, and we do have a very interesting space to work together where you are also invited to join the table. So I would like to highlight that we're not only inviting you to be part of the analysis, part of the dialogue table, but also helps us to generate those development models, sustainable development models based in rights that include your cosmovision, your justice needs, justice itself, peace, which are part of development. Without justice or peace, we do not have development, and we can go on. So we do have three necessary components. Therefore, I believe that we're there facing a truly interesting situation, a very important situation with the key countries. Well, you need to continue to be part of the table. And from your space, challenge us on how to improve with these development models. I think that the importance of this event and the importance of the agreement, and I commit myself as the resident coordinator in the region, because this is a result that I will communicate to my colleagues, not only Chile, for the results of the event somehow allow us to reflect on that very important side that sometimes is not that clear, very related to the context on justice. It generates great debates, much passion, and I believe that the scenario of the previous constituent in Chile, the colleague made a reference to that. It is a great example on how difficult it is to carry out this conversation on a national level, but also on how they are necessary, because deep down we do need to find models and warranties in order to defend the rights of indigenous people. I say goodbye here to wish for you to have a very fruitful session. It's an honor and a satisfaction to be here. Thank you very much. Thank you so much, Ms. Maria Jose Torres.
Very well, so now we will give the floor, the welcoming words as well to Mr. Gerard. Good morning, ladies and gentlemen. I am also welcoming on behalf of the High Commission for Human Rights, the regional office also for South America. I would also like to thank the resident coordinator of the system, Maria Jose Torres, our ally and ambassador, Thomas Pascual, from the government of Chile. I'd like to also thank all our team here for your excellent work preparing this event. And of course, ladies and gentlemen, also would like to thank you for your attendance, and I hope the active participation on your behalf during these 2 days. I don't want to talk about the results yet. We will be working towards gaining these excellent results. Nevertheless, we have a, let's say, constellation, unusual constellation, uniting operators of justice with the representatives of indigenous peoples. And the dream which we have is that the legal systems and the operators of justice can give back the rights of to indigenous peoples, like the coordinator mentioned, this long battle to obtain justice in situations which are sometimes challenging, as the High Commissioner Volker Turk mentioned. Before the extractive business of the farming industry at a larger scale, and this whole model as well of the Western world, which regards the land and the earth as a source of income, while for indigenous nations this land and territory is their home, their physical and spiritual home. All these are things that we'll be mentioning during these 2 days. Once again, I'd like to thank you for your attendance, and let us hope that we have 2 very, very productive days, and that we can contribute also to this alliance amongst the legal powers and the legal representatives on one side, and indigenous nations, together with a cooperation and contribution of the agencies of United Nations, not only the High Commission, but the families of the United Nations as a whole. Let's hope that this strengthens and continues. Thank you very much. Thank you very much, Mr. Pascual, Ms. Torres, and Mr. Gerard. I'll give the floor now. Oh, I invite you all to head back to your place, and I will give the floor to Pedro now, so we can continue with this event. Thank you. Very well, I would like to thank you very much for your welcoming words. Now, following the agenda, we will talk about the first segment, which will focus on the coordination between the legal system of state indigenous peoples' legal system and the access to justice for indigenous peoples. We have the honor of inviting Mr. Francisco Carle, Special Rapporteur of the United Nations on the rights of indigenous peoples, to give his keynote speech. This session will be moderated by Paula Veruti. Please, we invite you here on stage, please. Once again, welcome, ladies and gentlemen. As my colleague Pedro said, we will begin now, therefore, our summit and our dialogue here. Thank you. And now I have the true honor of introducing our Special Rapporteur of the United Nations on the rights of indigenous peoples, Francisco Calitzai. Francisco is Maya Cachiquel, originated from Guatemala, with experience of defending the rights of indigenous peoples in their countries and within the United Nations and the Organization of American States. Mr. Calitzai founded and was a militant in many indigenous movements and representative of before the United Nations. He was chosen in many consecutive periods to represent. He was Director of Human Rights and Foreign Affairs of Guatemala, member of the Presidential Commission Against Discrimination and Racism against the Guatemala indigenous peoples, and he presided the National Program of Resettlement regarding victims of the internal conflict or reparation. So it's an honor to have here our Special Rapporteur to give the initial footnote of these dialogues. The rapporteur here will talk about the coordination amongst the legal systems of indigenous peoples and state as mechanisms for access to the human rights and legal systems. This will be a 20-minute presentation. Then we'll have 30 to 40 minutes to answer any questions or comments from the audience. My colleagues will therefore give you some pieces of paper so you can write down your questions that we will process here at the front, and we will be receiving all questions that may rise from our platform as well, where we're broadcasting this activity. So without further ado, Special Rapporteur, you have the floor. Good morning, ladies and gentlemen. Of course, welcome to my brother and sister Maya and my brother Xinca from Guatemala for being here today. I'd like to thank the invitation also for being here. The Regional Office for South America, the High Commission of the United Nations for Human Rights, and to keynote speech about systems, legal systems, and indigenous peoples and state legal systems, which are systems of access to justice for indigenous peoples. So we're going to talk about a very relevant topic that we would need more than 25 minutes to mention all of this. So I'll try to be as brief as possible to offer some reflections and specific recommendations as well. Keeping in mind that the following briefers will talk about these topics in detail. So some of the issues that I will generally give an overview. Now, if you keep in mind also that not only is there a legal system for indigenous peoples, but that each indigenous people have their own legal system. We would have to therefore carry out a seminar, not of a week, if not maybe a month or a whole semester, to talk about all the legal systems which exist within this continent. So international regulations of human rights therefore do recognize the right of indigenous nations to maintain and to develop legal systems and their own legal systems and their own institutions. This right is under to the right of free determination established in Article 3 of the Declaration of the United Nations on the Rights of Indigenous Peoples. In detail, the right of indigenous peoples to maintain and develop legal systems and legal institutions of their own. This is established in many international instruments of human rights, like as in Article 4 and 5 of the Declaration of the United Nations, Article 8 and 9 of the Agreement on Indigenous Peoples, 169 of the International Organization, the International Labor Organization, and Article 22 of the American Declaration on Indigenous Peoples, the right of indigenous peoples. For a detailed analysis of the regulation of international regulations that establishes the right of indigenous nations to their own legal system, I will talk about the analysis contained in the report of 2019 regarding this mandate on access to justice, ordinary and indigenous. This report concludes that the indigenous legal systems could comply with the legal system which is social and cultural, which is fundamental on the protection and the rights of indigenous peoples. We were hearing the High Commissioner talk about the legal operators or legal agents of indigenous peoples that are more closer to communities and their own people. In this sense, the report mentions that in practice, indigenous peoples continue using the indigenous legal systems, majority of times due to their geographical and cultural proximity, also because their own justice system can respond to the lack of legal protection from the state, especially in contexts where the access to justice is denied for indigenous peoples as a result of racism and racial discrimination. Let us remember that the states in this continent, their main base is on racism, racial discrimination, and exclusion of indigenous peoples. We do know that in Latin America, many states have recognized the right and indigenous jurisdiction. In certain cases like Colombia, Peru, Bolivia, Ecuador, and Venezuela, also at a constitutional level. Even though this recognition has been given, there are many setbacks to overcome for efficient and equal system between the state system and the indigenous legal system. An issue generalized that I have encountered as a narrator, a reporter, concluded in the report of 2019, is that the scope of the legal system of the indigenous peoples many times is limited based on a racist vision, which is hegemonic and racially discriminate. They regard indigenous people like inferior and underdeveloped. For example, there is the generalized belief that the indigenous right only is applied to specific areas or conflicts of less amount, like we're talking about interfamily or domestic issues. It does not recognize the complexity of the legal system of the indigenous peoples, which is holistic. It regulates comprehensively all aspects of collective life. Of course, we must recognize also the huge diversity of legal systems of indigenous peoples that vary from one community to the other. For a coordination amongst indigenous legal systems can be coordinated with the state to be paritary and effective, the first barrier is to overcome discrimination and racism before the indigenous legal systems. I hope that my recommendations can show a path to overcome this situation. Now, talking about coordination amongst between legal systems, the main issue is to define the criteria for competences of these two legal orders. Now, I do know that a whole section of the seminar is dedicated to this topic. Therefore, I will briefly share with you some general reflections. One of the criteria identified by many legal orders to define the competence amongst the different state and indigenous legal systems is the territorial criteria. Regarding this criteria, one issue is the lack of correspondence between the ancestral indigenous territory and the political administrative division of the state, which is used usually to define state jurisdictions. I will give an example, which is not in my discourse. Nevertheless, I just remembered it. It's not from this continent, if not from the African continent. I was talking with a representative of the Tuareg people, and he said he had been imprisoned many times just for crossing the border. A border, he used to say. When he said, my territory goes through the whole desert. And I had never been imprisoned up to now, he said. When the police, because he was accused of a felony, he said that you've violated international laws, because if you cross this border, international borders. And he said, that's not true. I haven't crossed any international border. The international borders cross my land, because before these limits and frontiers did not exist. This is how the question rises of territories. One of the identified criteria by different legal entities to define the competence amongst or between state and indigenous legal systems is the territorial criteria. Regarding this, an issue is a lack of correspondence. Well, I just mentioned this. In the case of indigenous legal system or jurisdiction, there must be defined from the concept of territory, which is established, or the international right. In particular, under Article 13 of Agreement 169 of the International Labour Organizations, which considers the indigenous territory as a whole of the habitat of regions where indigenous people use or live, or they use up in any sort of fashion. This means that the indigenous legal system should not limit itself just to the territory, formally speaking, recognized by the state, if not the traditional territory used by indigenous peoples, which is a more broader sense than the geographical lines. This is where they reproduce their cultural and social life also. This also has important implications for indigenous peoples who live within an urban context as well. Although there is no territorial fiscal territory, there is a space of reproduction of indigenous culture. Another main aspect for the coordination between is the identification and recognition on behalf of the state's legal system of indigenous authorities who are in the legal system. Now, the state legal system, due to its excessive formalities, finds difficulties to identify and recognize indigenous authorities, which are competent to exert indigenous justice. In this sense, each community has different institutions which administrate justice, and in many cases, justice is exerted by different institutions. For that reason, the legal order of the state must abstain themselves of imposing rigid and formal criteria to identify, therefore, the indigenous institutions of justice. The effective coordination must take into account the diversity of each community and leave these community of indigenous peoples the ones to identify their own institutions based on the principle of free determination without having to adapt themselves to impose criteria by the state. I must mention the sentence of the Constitutional Court of Ecuador, which establishes as a base to identify the indigenous authorities, their own right, and not on behalf of institutions of ordinary justice. In the majority of state agencies and entities, succession of procedures and regulations of indigenous are under institutional control on human rights. I was going to comment there, but I don't have time, so I better skip that, and I'll just continue, because there's a lot to be said here. That's what I'm saying. 25 minutes is very little time, or 20 minutes even. So the position is our position to recommend that both state and indigenous legal system must respect and apply the systems of human rights within their procedures and decision making. Nevertheless, the issue is found when the respect of human rights is used by the state order to delegitimize or to not to recognize the indigenous jurisdiction. For example, using the argument that the indigenous systems do not respect this due process. Obviously, a parity relation between both legal systems do require for there not to be hierarchical subordination of indigenous systems before state systems, and or in the case of control by a superior organization, that this is a suppression from both legal systems and not just from the state system. Awaiting this real parity, this office urged states to interpret a dynamic and intercultural point of view in the context of non-discrimination against indigenous peoples as an important element for the legal authorities of the state, which insist in examining the legal processes of indigenous nations. So an important space in this direction has been taken by the constitutional courts of Ecuador within a decision of which was carried out in 2021, which back then, when they examined the vulnerations to this process and or the defense in the case of indigenous justice, it must be intercultural focus must be employed, and starting from the regulations and their own processes of communities and under the principles of autonomy in their decision making. In the same line, constitutional courts of Colombia and Bolivia pronounced themselves as well. One of the main obstacles for the effective exercise of indigenous rights and legal systems is the non-recognition of indigenous rights and international standards of human rights of indigenous peoples. This problem has affected all levels of jurisdiction of the state system, including higher courts like constitutionals, which are the ones that in certain cases pronounce themselves on the competence of indigenous legal systems. Also, the protection of fundamental rights such as the right to land and territory. Many times, depending on the composition of judges and of the knowledge of indigenous law, they have established different competences throughout time, not only following the established procedures of institutional legal system, which this operates on a more local level, must coordinate and must encounter communities or engage with the communities of indigenous nations to understand and appreciate the specificity of their legal systems and legal processes. Throughout my mandate, I have observed that the lack of knowledge or legal knowledge from human rights of indigenous peoples are an obstacle for recognition of the right to land and territory. Even the protection of fundamental rights such as the right to religion and spirituality of indigenous nations and the right to development cannot be protected if the legal system does not adopt an intercultural focus, which keeps in mind indigenous rights and the epistemology of each community. To encourage the coordination and commitment between legal systems, the judges of all levels must be trained on human rights of indigenous peoples and have some knowledge of indigenous rights. In equal legal system, cooperation between jurisdictions must guarantee the decision-making of indigenous justice as well. Unfortunately, even though that in certain countries it's mandatory to have an indigenous legal system, de facto there are obstacles in certain cases because the decisions of indigenous justice does not have the power to modify legal issues existing within the governmental institutions of the state. Therefore, It is necessary that the coordination does not to comply with the legal system at a state level, but in all state institutions. The coordination and cooperation between the two legal systems is also necessary to guarantee the effective application of the decisions of the legal power of the state. There are specific cases where the authorities or indigenous authorities are better positioned and equipped to execute legal and state decisions and or legal activities such as notifications and give testimonies. Other commitment is the recognition and respect of indigenous police. From this point of view, we can see a best practice in Canada, where the service or the police service is CLAMIC. CLAMIC is the only administrative police system administered by the British Columbia Indigenous Nation. This CLAMIC police is a police unit allocated under the law of police. Another crucial point of the legal system of the Indigenous nation is the coordination between the penitentiary state system and Indigenous justice. As we know, the penal Indigenous law is based on the criteria of resocialization and not retribution. From this point of view, we must mention the case of Canada, where the law foresees different alternatives than imprisonment, which do allow indigenous peoples condemned or to fulfill their sentence within their community. The states have used different instruments to encourage the cooperation between different orders. For example, in certain legislations which recognize the indigenous jurisdiction has adopted or are adopting laws of coordination, and as these laws concern indigenous peoples, and they must be consulted with them and approved after their previous consentment, which is free and informed, such as established in the international right. Unfortunately, in certain countries, these legislations of coordination has been adopted and proposed without consulting indigenous nations. Another criticism is that the law is an instrument which is too rigid to regulate a reality so complex and diverse, such as different legal indigenous systems of the country.
Very well. So, in general, I consider that in order to guarantee efficient, efficacious cooperation and also equal, it is necessary to adopt a bottom-up focus based on the proximity of justice, state-owned, with the communities of the indigenous people, in order to adapt the cooperation mode to the specificity of each community. For this reason, I consider that the protocols for coordination and cooperation with the state-owned corporations, such as the legal entity, the public ministry, are a proper cooperation tool when queried appropriately with each community. Now, the protocols can be flexible tools in order to identify with flexibility the indigenous institutions that are responsible for the execution of justice in each community, in order to define the competence environments between the state competences and indigenous competences to promote cooperation among them. For instance, the use and collection of tests and the execution of the decisions of state justice and indigenous justice. A very good example of implementation of legal pluralism is the Oaxaca example in Mexico that has created an indigenous justice room with the higher tribunal of the state of Oaxaca. I will not stop in this point because I have seen that the topic will be talked about, and I've seen that in the program we have the magistrate Barbares Vargas, that he will be speaking about the important initiatives adopted in Costa Rica that I had knowledge in my official visit in 2022. In Bolivia, the Vice Ministry of Indigenous Justice have been stated the originary person that has promoted a room to dialogue with interjurisdictional dialogue with the justice ordinary operators or indigenous share their experiences to generate coordination mechanisms and jurisdictional cooperation. In Colombia, the administrative room of the Higher Council has created the National Commission for the Coordination of the National Legal System and the special indigenous jurisdiction is a permanent instance of communication, agreement, and follow-up of public policies from the legal framework in terms of jurisprudence for indigenous people. Out of the continent, in Timor-Leste, the government has committed to develop a justice hybrid system that includes indigenous justice and has foreseen to celebrate consultation processes with the communities of the indigenous peoples of all over the country on how to achieve coexistence, a harmonic coexistence of the state justice system and also indigenous systems. In Australia, the Koori Tribunal from Victoria have the advisement of the elders from the Koori community to adapt the acts in such a way that are more appropriate from the cultural point of view, and also to identify alternative penalties and to reduce the amount of incarceration. I will shorten this and say that I will read the recommendations. The first recommendation is key when elaborating laws or other measurements that affect the indigenous people. The state can have a consultation process with indigenous people with good faith to achieve their free, previous and informed agreement before adopting legal or administrative norms that may affect them. The state must provide financial appropriate resources to support indigenous justice according to what was established in Article 39 from the Declaration of United Nations on Indigenous Peoples' Rights. 3. The state must include a mandatory training, education on conditions, concepts, and methods of legal indigenous systems in official programs for training of judges, lawyers, district attorneys, and agents of order. Every time a judge goes to a shared jurisprudence area must have an induction training course with update in indigenous justice. 4. The state authorities, indigenous authorities, must study the possibilities to establish joint mechanisms for cooperation and coordination equal between indigenous justice and state-owned justice systems without stop recognizing that each context is different. It would be good to talk about the idea of adopting models that allow to submit to a revision or appeal the decisions from the indigenous systems and not indigenous through a legal common organism integrated by legal indigenous authorities and non-indigenous authorities. 5th, the state and the indigenous legal system must be developed and institutionalized an exchange of information process for understanding and mutual education. 6th, to overcome hierarchical subordination of the indigenous systems to state-owned systems, or in the case of control, with a higher organism that is agreed between both legal system and not only a state-owned system. Even though I agree that the state must review what was acted by indigenous authorities in countries where the legal state authorities make a revision on the decisions of the authorities of indigenous justice, the ordinary tribunals cannot make fair and unbiased decisions without cultural understanding of indigenous people, their institutions, and their legal systems. The experience for coordination must be visible and of public knowledge. 8. Finally, the state must provide efficient resources in order to support revitalization initiatives and strengthening of institutions from indigenous people and their right. For that, it's important to support the creation and the work of the universities, indigenous universities. Matthias Javert, you want to have. Well, Rapporteur, thank you so much. I will ask all the participants and attendants, you have in your folders papers this size. If you can take us and notify, if you can bring us, if you have any questions, any doubt, that is the way. My colleagues can collect them and then we can process them here in the table. We will have about 15 to 20 minutes so the rapporteur can answer your questions and then we can continue to dive in these such powerful aspects that were mentioned connected to the, well, beyond the recognition, beyond positive aspects related to international recognition of the rights of indigenous people, individual and collective rights, but also the recognition in some of the states of our region. In principle, they are so fundamental, such as self-determination, free determination in affairs that connects them to the full execution of their rights that brings us here to this regional meeting, which is racism and discrimination that jeopardizes somehow access of indigenous people to justice in equality conditions, and issues that are not minor, such as territory, the borders, the land, and the execution, full exercise of when there is no recognition of borders, when the borders were not there, right, when the people were among us. And so, of course, it's not enough time. I don't want to misrepeat what the rapporteur has presented so deeply. So, a couple of questions. We're going to process them jointly, okay? We have two questions related to the challenges of justice access for violent cases against indigenous women. What should be the role of the state? And also if the rapporteur can share some examples on some advances related to, once again, access to justice, specifically for women. Rapporteur. I think that is the role of justice, indigenous justice. There are cases, and I don't want to mention countries, but I do have knowledge on how indigenous justice systems discriminate women, indigenous women, even re-victimize them, humiliate them. I've known about how some companies have had the ball to use state justice systems to humiliate women, have been bold enough to do that. And in a sense of that women are the ones that suffer directly that racism and discrimination, racial discrimination, due to the fact that they have been the ones keeping that technical and scientific knowledge in the communities of indigenous people. And in many cases, women are the ones that have that knowledge on the application of justice. It's not that I'm saying that the indigenous justice system is perfect. However, there's much more access for indigenous women in the system, in the indigenous system. Something that is not visualized despite equality when facing the law in the state legal system. So we have several examples. Unfortunately, as I repeat, unfortunately, the mandate does not allow me to mention specific countries in this sense because of the fact that there's an internal regulation from us that says that I cannot mention a country unless there was previous communication to accuse or denounce the violation of indigenous peoples. However, there are several cases all over the continent, Yabe where we can see how women have suffered that racism and racial discrimination in the official justice system. And apart from that, they can have access to more direct justice coming from the indigenous people. Let me tell you that I have been able to prove that in some state where we have indigenous people, we've seen how some indigenous authorities have violated that right of indigenous people. But it is more generalized in the state system more than in the system for the indigenous justice application. We can say that between 100 state-owned, 5, maximum 10% of discrimination against women. Thank you, Repertoire. I'm going to collect some of the questions related to that same topic. So what is the suggestion so the state can establish originary indigenous justice, taking into account that each people is different and wide? So how can be compatible customs and indigenous justice in a country where the non-indigenous justice is primary? I think that what we need to start is decolonizing our language. The indigenous justice system, here we have a colleague, I know her since the 90s. When arguing back then about the fact that to discriminate the indigenous justice system, you would call it a costume. So that we do need to start even to remove that language that the indigenous justice systems are costumes. It is an established legal system. I remember the discussion we had back in the 90s. I had to lead the constitutional reforms of the country in the context of peace agreements. And when speaking about indigenous justice, I was asked to prove if within the indigenous legal customs there was a penal, criminal, civil, work, family law in there, and all of these branches of law, state legal jurisprudence. I remember that we had a legal sacrilege, and we made the comparison. We made a comparative study back then where we were proving that there was, in fact, criminal, family law, but it is in the context of the application of indigenous justice. It is holistic. It is not essentially visualized, okay, this is the branch, we're going to study the legal branch, I'm sorry, the criminal branch, the civil branch, the work branch. No, it is not. In a system, it's a whole. I was even asked, is there a proper process? Is there, in this due process, defense right of the accused or the defendant or the accuser? So what happens is that we have two very different systems, and yes, there is right to defense. So that's why they are the largest, the ones that made the application of this justice. The elders. I remember in my people, the elders, men and women, the elderly are the ones that take their, let's call it, the speakers, and the spokespeople are the ones that are going to defend or accuse. So there are many things related to this situation, and we do have right to defense and a proper process. So in that sense, I go back to what I said previously, that it is necessary to start knowing and being more open in this issue of knowing that there are different legal systems. I remember that I was told back then, the problem is not legal, but recognition to justice, indigenous justice. It is political in such fact. Why? Because if we recognize the legal system, in this aspect we will recognize 500 years of legal, juridical racism against indigenous people. So I think that that is what truly is there. It's on the discussion table, because even I remember back then some stories where it was proved that justice, indigenous justice, had saved millions and millions of dollars in the legal costs. Why? Because those applying justice in indigenous people are not paid. They are not paid for it. It is a community type of work. It is a social service type of work coming from the community. So there can't be corruption. No, these things don't exist. Things that we know about the state legal system in the continent, so there's a lot to say. We could spend the whole morning today, all day long, all week long, speaking about how it should be recognized and applied, the legal system of indigenous people. And apart from that, I'm only speaking about one legal system. If speaking about all legal systems that exist in the continent, I don't know what we could do. Thank you, Francisco. I have a couple of questions here. I think they have been answered, though, because they are related to indigenous justice, a due process, right sources, indigenous criminal sources. So how to overcome polarization. Sorry, I can understand the handwriting. I don't know who wrote this. I don't know if you can. And I formulate the last two ones. I'm sorry. Speaking about how to overcome polarization of the political parties to carry out our jurisprudence with political parties. Well, the thing is that indigenous people in this moment are not exempt from political parties. But if we apply indigenous law, it is related to the party. This is a situation that we need to start taking into account. It does not belong to a political party. The indigenous authorities, and sorry for what I'm going to say, I know that I should not make any comments to what's happening in my country in this moment. It is a clear example of what can be done at that point. So the authorities, indigenous authorities, do not respond to any political party. That's why they are leading now everything that is happening in my country without answering to a specific interest of a political party, and they have clarified this quite a lot. So that is the reality. Indigenous authorities, when they are really indigenous, do not support any political party. Francisco, I have three to finish. One related to the international jurisprudence existence on the administration of indigenous justice, as I write. The next one related to concrete recommendations on how to guarantee indigenous justice in urban contexts. Understanding there is a large population of indigenous people inhabiting the cities. We have 5 minutes. They're giving me the yellow card. And another question for the end. It's in the end, how to avoid the states to use the human rights speech or women's rights to avoid the use of the subordination of the rights of indigenous people to ordinary justice. I don't know if I explained this correctly, sorry. Yeah, you explain yourself, but I don't really understand why women's rights is to subordinate the indigenous rights to related to the state right, for the fact that, well, this is something that should not happen, to use human rights for this type of situations. However, I believe that not only women's rights, but human rights in general have been used to subordinate the indigenous legal system when thinking about the state legal system. In the context of urban indigenous people, the ILO, and here I will quote ILO, 4 years ago made a study that says that 52% of indigenous people or indigenous population lives in urban areas. It's not an issue of, and I want to clarify this. If there's any social scientists, anthropologists, I'm terribly sorry, but the anthropologists have been those to blame about ruralization of indigenous people. Because those who live in urban areas are no longer indigenous. Those who no longer have a connection with their communities are no longer indigenous people. It's a lie. And I'm sorry to repeat myself, it's fake. That is a fake theory. The Mayas lived in great urban areas. The Aztecas also urban areas. The Incas also in great urban areas with their own legal system. So there are some issues that have come to mystify the fact that the indigenous need to be rural, something that is not true. And so that's why I was saying that in the urban context, that's where we've seen more problems in the application of indigenous justice issue. Why? Because let's remember that in urban areas we do have a concentration of the state-owned jurisdiction. That's why there's a higher reproduction and application of indigenous people in rural areas, because it's where the judge, men or women, doesn't want to go. So there's no application of justice in the rural area. And so that's where authorities have been strengthened, has become stronger, because of the fact that there's no interest coming from the state to deal with those rural areas because of the distance. They don't want to stain their boots with mold, as our people do so for the application of justice. So there are several things, and mainly it is political will, but also consciousness that we need to fight against racism and racial discrimination that exists in order to recognize the different indigenous legal systems. Francisco, thank you so much for this presentation, for answering all the questions from the attendants. Now we will continue with the meeting. Pedro, yes? Are you giving the instructions? Thank you, Pedro. Thank you, Mr. Francisco, for those wise words and for sharing such valuable experience. Very well, now, to those who are connected remotely online, we will have a break in the virtual session, and we will return to the beginning of the plenary session, for the beginning of the plenary session afterwards. From now, 10:30 until 11:30, we will go to the different workrooms. These are rooms in this floor, and then we're going to have a break between 11:35 and 12, during which we offer a coffee break that will be outside in the halls. We will come back to the activities in this room at 12 for the plenary session of the rooms. So from now, we tell the assistants to go to the tables you have enrolled. Table 1, Los Andes room. This is this one. Table 2, yellow, in room Lima. And table 3, green, in room Bogota. My colleagues will be available to guide you and help you to your corresponding room according to what you have selected this morning. All rooms are in this floor. It is extremely important to highlight that table 1 and table 2 will have translation service to English and Portuguese, but the table number 3 will be carried out exclusively in Spanish. We also invite you to use the QR code that will be in the doors to enter the WhatsApp group that we've created for this event, where we're going to be sharing useful information for your your participation to be the best. Thank you. in a couple of moments, we will share on the screen the QR code. So to enter, you only have to take a picture with the code, and from there, this will take you directly to the WhatsApp group. Okay, so we can start broadcasting virtually. And to begin the plenary session, we will invite out of the three tables the three speakers that were identified on the three tables. Table 1 on constitutional recognition and secondary law, the normative consecration and good practices, challenges, limitations, and good practices in their implementation. Table 2, elements of the due process in the criminal environment in the application regarding indigenous jurisdiction and access to justice in conditions of equality. Table 3, coordination on legal system, distribution of competences, the articulation of indigenous systems, state systems, and human rights as a paradigm for dialogue and coordination. Please, the speakers, the spokespersons of each table, take a seat, please. Do we have the spokespeople? I also invite my colleague Dia Diaz from the office from Honduras to moderate the presentation of the plenary session. Please go ahead. Just one report before giving the word to Indira. For this plenary session, we have 45 minutes. Thank you. Good morning, everyone. Thank you so much again for being here, joining us in this regional dialogue on indigenous people and access to justice. In the case of the plenary session, we have chosen 3 people as rapporteurs from each one of the tables for them to explain in a 6 minutes term what are the discussions that happened on each one of the tables according to the topics that have been established. Let's remind you that in Block 1, the topic approaches coordination between systems, justice system, indigenous state justice systems as mechanism of access to justice from indigenous people. In that sense, we will be talking on each one of the tables, starting with Table 1, the issue of constitutional recognition and secondary laws between regulatory consecration and practice, challenges, limitations, and good practices in their implementation. So we give the microphone to our colleague Andrea Serrani to proceed and gives us the summary. By the end, when finishing, in the expo and in the lecture of each one of the people, we will have a dialogue space for the discussion and questions and answer. Good morning, everyone. And on Table 1, we've seen the issue of the recognition, constitutional recognition, and also the challenges and the barriers that are faced in the different countries. The table was very interesting, and so in a non-methodological way, but we have determined someone, Hector, sorry, that will support us with the main issues, the main points that have been identified on the table. I just wanted to thank from the table and to recognize all the supports that we have received, whether from the people, from the audience, and the speakers also. Yeah, well, I repeat the good morning. For those who don't know me very briefly, Hector Guardo is a lawyer from the Cuna people from Panama, and I dedicate myself specially to carry out indigenous processes in the system of human rights where we work internationally. The table was quite rich, diverse to me as a member of an indigenous people that's quite satisfied because of how deep and interesting is what's happening in the region. Hopefully this can replicate itself in each one of our countries. One of the key aspects that came is that yes, we do have a constitutional recognition, not from all states, some participants. I will not speak about one specifically, I will just make a general summary of what I was able to see. There is constitutional recognition regarding indigenous justice. And it's interesting what was mentioned by one of the members, that it is unnecessary for our conditions, and I completely agree with that interpretation, that textually in our conditions to see that indigenous justice must be considered. But better yet, much was said about the conventionality principle and international tools, instruments for human rights. And it was spoken by the rapporteur at the beginning. To me, that was quite clear. Not necessarily the Constitution needs to specify the issue that indigenous justice is living and updated, as the speaker said, and that is a first glance of what is a general conclusion for Table 1. Another key aspect was mentioned by the people there. It is the topic of rights when thinking about conditions and internal laws. And it's interesting because much was said about the land and the sentence that have happened in the different states where the participants have talked about, from Ecuador, Mexico, Costa Rica, and if I'm not mistaken, Peru. Those were the 4 people that also said that indeed it is not necessary for rights of indigenous people in the legislations to be so specified. So in a constitutional form, those rights are not recognized. The rights of land and territory and resources. Some said that there were some sentences when, unfortunately, with extractive companies, everything related with the territories, indigenous territories, and I think that that was a second topic that I thought was very interesting. Something that it's concerning, that was also mentioned in the table, the issue of what we lawyers understand as jurisprudence. Unfortunately, in most cases, our case studies, some countries, one of the members said that actually there is jurisprudence. Hopefully this, in 10 more years when we meet, it's going to be a trend in the region. There are some countries that have jurisprudence when thinking about previous consentment, free and informed previous consentment. Unfortunately, that is not the case in the regions. That is another approach regarding the issue of sentence. And finally, something key that was mentioned. It is, for us indigenous people, is very important, and it is the necessary appropriation of indigenous people on their country level of states as a political flag, the issue of justice, because we also have some trends that not only happen in the cases where you wish to qualify justice of legal pluralism or indigenous people as a segregation, a part of the state that must not be accepted, and has allowed to put some barriers in the constitutional knowledge of the rights of indigenous people in some of the states. So that makes us, there are some indigenous people that have done so successfully, such as the Pau case, the Bolivia case, some other cases where the indigenous movement has been quite strong. One of the demands has been the recognition of legal pluralism. In summary, this was mentioned among the four of us, and several interesting decisions were made. I don't know how the table for coordination of this event will happen, so we can connect, attach ourselves to these expressions, legal expressions that were mentioned today. Thank you. Thank you so much, Hector, for your summary. Regarding the topics developed in Table 1, like legal pluralism and recognition of indigenous justice, with some failures in the case of Ecuador and Bolivia, and also the needs and challenges that exist for the implementation of or recognition of the indigenous system in each one of our states. Now, we will continue with table number 2 that spoke about the topic related to elements of the due process in the penal environment in the application of respect to indigenous justice and access to justice in equal conditions. For the synthesis, it was chosen as a rapporteur Leopoldo Antonio Huichala, and Darling Garcia. Leopoldo. Thank you, Marimari Pupeñi, Marimari Puliamien. Good morning, everybody. Brothers and sisters, I introduce myself, Leopoldo Antonio Huichala Garcia. I am a lawyer from the Research Center and South Defense. I dedicate myself to the criminal area and the defense of people, indigenous people and non-indigenous people in a context of fundamental violation of rights on behalf of the state. A few moments ago, we had a conversation, a brief conversation, but very rich conversation. And in definitive, we've talked about two very important topics. One of them is what are the gaps in the recognition of indigenous justice systems. The speakers spoke and said that one of the main gaps is this overlapping of the jurisdictions that overlap, as it was pointed out as a rapporteur a while ago, in the state justice system above the indigenous justice system. That is a gap that exists, that should be talked about and solved about this topic. And another existing gap is the lack of political will on behalf of the states when thinking about recognition and strengthening of systems, jurisdiction, indigenous system on behalf of the people, and also structural racism when thinking about the recognition of systems, justice, indigenous justice systems, as it was mentioned by the rapporteur. Also, as it was mentioned, there is an imposition historically of the church authority on top of the system, when based on the system of indigenous conflicts resolution system that has existed systematically on behalf of what we talked about on behalf of all state. There is this overlapping and this imposition of the church authorities when thinking about the justice of people. A second topic that we talk about, the good practices that have been adopted and that we can adopt, that states can adopt, regarding the strengthening of the recognition of justice systems of the people. One of them, as it was mentioned by Mariana Jumbay, it is the strengthening of community governments with a community assembly. Another one, the existence of principles and procedures in the application of indigenous justice. Many times has been said that the indigenous justice does not have principles or procedures, processes regarding the application of justice, and that is not true. There are processes, historical processes, and how to say it, principles and procedures, historical, that are different according to the different cultures in the application of the conflicts resolution on behalf of the methods of the people. Another element we talked about which makes much sense. It is according to the increase of poverty in urban areas and rural areas that has been given because of COVID during these times, and the following increase of criminalization and crimes. There has also existed, as Jacques Lema brother says, an approach on behalf of those who have been put on trial with the application of indigenous justice. So this is something connected hand by hand with the it's connected to the increase of of poverty, right? So it's extremely important to keep it in mind, to keep this approach in mind on behalf of people, to solve conflicts through the application of the justice of people. So this is what we talked about in brief words. Thank you.
Thank you very much, Leopoldo, for the summary here. And we'd like to point out the issues that were discussed in table number 2, like the existence of these gaps in the recognition of the legal indigenous systems, and also the overlap of different state systems as well, related to the justice systems of indigenous peoples, and the best practices, the strengthening of community governments. Also pointing out the challenges which still persist regarding the criminalization of peoples of indigenous heritage. So, following the next to present the summary of table number 3, which main issue was coordination of legal system, the distribution of competences, the articulation of indigenous systems and state systems, and human rights as paradigm for dialogue and coordination. Therefore, we have Claudia Ignacio, who will briefly summarize these topics. Good afternoon. I'm Claudia Ignacio Alvarez from the Purépecha people nation. We are in Mexico, located in the state of Michoacán. The conversation here was, I think it was a bit challenging in many senses. We were talking about this part of the coordination of the legal systems, and the first thing that came out was the need of autonomy. Autonomy regarding the legal system, indigenous system, regarding regulation of indigenous nations within their own systems and their own practices. And this was what led us, this legal autonomy, led us in terms of thinking that coordination of systems sometimes goes more through agreements that can be taken, which could include good intentions, but at the end of the day are not really translated in the practice. Here in the practice is where we really identify the major limitants. For example, it was mentioned that in the recognition of this legal pluralism, which in many countries it already is a reality, but the truth is that still at the moment of exerting these things, we find different suppositions and certain problems or complications, for example, to the identification of the players or actors who are intervening within the legal dispute, and how these actors or people can have different languages and different positions. A couple of colleagues here who are defenders here were talking about that these practical limitations at the end of the day are translated also into a lack of respect or guarantees when defending human rights on behalf of the indigenous nations. So therefore this situation of constant risk where people, the defenders, are actually, well, that's how they live. These legal systems, therefore, is even more complicated because there's no guarantee or certainty there will be no more criminalization processes, or that the local authorities will not attempt against the defenders. Also, there's a structural issue of political projects in the case of the state, because we still see certain states that are focused totally on developing mega projects. a model or a way of life that does not agree with the way of life of indigenous peoples. So from there, it was mentioned also about this autonomy, which in formal terms is very well defined, but in real terms, not necessarily is put into practice. What we can appreciate in reality has precisely to do with this resolution of legal situations, like in majorities and minorities. The last briefer told us how this rapport between minority and majorities seems to be a public policy which is, sensible, but ends up affecting the rights, even ancestral rights, and did not achieve the dialogue. Within this coordination of legal systems, there seems to be a huge issue of communication here. That's on one side. And the other thing is that it's not clear whether the path to follow has to do with autonomous systems, and it was mentioned also those peoples who not necessarily having a legal practice, a formal legal practice in force, or they had included within their practices different elements of rights, law. So these are combined. I think the agrarian issue was one of the most clearest thing, how these practices combine, legal practices combine within their own people. And it's necessary for these to dialogue. This goes through a flexibility process as well. Well, obviously many things were mentioned. For example, how come that the states, in different cases, are taking on international law to implement them and to allocate legal processes from exercising this international right. So therefore, it can be enrooted within or embedded within the the States and nations. And I think there's much more to do on that topic. But that's just in a nutshell. Thank you very much, Claudia, for your summary. Now, table 3, where we need the need of autonomy or indigenous autonomy to proceed to real coordination, which can allow that the agreements can be translated into the real practice. Also, there's a challenge like the lack of respect and guarantee of people's defenders of human rights, of indigenous nations. This is an important challenge, therefore, to achieve this coordination. So now we invite you all to write down your questions to each of our colleagues and participants and of each table, spokesperson, all your comments, all your concerns, and just to remind you that this is an invitation from the High Commissioner of the United Nations, High Commission of the United Nations, to reflect on the Universal Declaration after 75 years of its adoption, so we can exchange best practices, ideas, and also challenges that may exist regarding access to justice on behalf of the indigenous nations. So please, if you could just write down your questions or comments or any inquiries or suggestions on your pieces of paper. Thank you. You can write it down, but also if you wish to use the microphone, we have it available for you. Thank you very much. So, I just wanted to mention here the conception of coordination and and cooperation also leads to the submitment and subordination of the effective application of the rights of indigenous peoples. So I just wanted to warn this. So we must precise, so we don't work on this. Now, legal pluralism many times leads to a certain rhetoric. In the case of Bolivia, this is fundamental. The issue is whether concrete practice can truly resolve the issues of indigenous peoples. In this sense, the autonomy should be considered as a basis. Nevertheless, based on the reality of this era. So there was a word that came out here, pluralism, that many times this word rises from reactionary groups, really, who deny the rights of indigenous peoples. Many times the same rights of indigenous peoples are used to deny the effective application of indigenous peoples. So therefore, from my point of view, it should be precised. The autonomy must be precised and pointed out in the practical terms of the application of indigenous peoples. Thank you. Well, as I'm here, I'd like to take the opportunity to point out something in particular. It seems that something that would be important to be mentioned here is the focus itself. Decolonizing focus, because during these past 20 years, the intercultural image is enforced now, and it's like a criticism, a dialogue amongst cultures. It is carried out in an equal manner, but in many views, the concept of intercultural justice has been used to subordinate the indigenous legal systems and to control them through the constitutional courts or even penal courts or criminal courts. So the constitution, in Ecuador, they say that they have to control and be alert of about the indigenous legal system. So I think the focus here, which is the decolonizing focus, is fundamental to eradicate the discrimination of women. Also says, with the neocolonialism, it's not possible to guarantee the rights of men and women as a whole. So we do need to avoid or to change, to amend or decolonize this relation within countries regarding indigenous peoples. So therefore, truly, the rights of indigenous women can truly be enforced, to strengthen the participation of women within the legal system. So there may be a total exercise of rights. So I just wanted to mention that decolonizing factor. I'm Jimenez Cáceres from the Aymara people here in Chile, and I just wanted to have two reflections here. One regarding indigenous justice. I do believe that it's very important to go in hand with the rights of revitalization. It happens that here in Chile, the indigenous peoples themselves, due to our Chileanization in a way, have lost our legal systems or regulations which were practiced up to not long ago, in fact. And in fact, it happens that the indigenous people themselves prefer to go to the state law, to appeal to the state law, even though that the indigenous law has also been applied. So we have to revitalize and give more empowerment over organizations, and we need the support there. And the second thing is that the coordination or recognition of coordination amongst indigenous and state legal system must base themselves on the practical reality of indigenous peoples. The Chilean example of the Aymara people, currently there's still conflicts of limits or intracommunitary or within borders. So that's important. But the indigenous people themselves, I'm talking personally nevertheless, there are other matters they would prefer to leave to the state justice system. So we have to seek some sort of regulatory model which starts off from the efficacy side, so then the legal systems can be efficient in practice, and also this right to revitalize things. So little by little, we can actually recover our own justice system, and therefore we can guarantee not only our autonomy, revitalize our culture, our language, our cosmovisions, but as it has been mentioned, more elements there are more elements more important, such as justice and language, and then therefore we will have more voice, and we won't have the risk of, well, losing in our own autonomy. Thank you. Very well. Table 3. I participated in Table 3. I want to participate and to mention that more than a question, this is some sort of something that we ask ourselves amongst the communities and amongst ourselves, we defenders. The way how justice is applied, in other words, justice in this case Mexico. The reason why I ask is because the justice for us is that all our human rights are respected. That's what it means for us. Everything that is ours also must be respected. In the case of Mexico, with this mega project and all mega projects being carried out that the government is actually approving and imposing, because it is an imposition, how indigenous peoples and non-indigenous, we have take care of the land, of the territory, we have taken care of the forest, the jungle, the animals, and right now, for example, within the biosphere Calamur, we and other peoples, I don't know what they call here in other countries, but if we started to use the land to build our own houses, they arrested us and imprisoned us. But now, companies were given the permit, or maybe not even a permit, but they're building in the middle of the forest a 144-floor hotel, plus everything that leads to, I mean, everything to do with infrastructure, the casino, game rooms, everything in the middle of the jungle. So, do you think that there's justice there for indigenous peoples? There's no justice there. We do not have that right. So, the way on how these governments and companies and extractivist industries are collaborating together, confabulating, and not just in Mexico, around the world. So, justice is not applied in this case. I've been in many forums and many conventions, in this case of the United Nations, and companies, and the World Bank is there present, and we say to them, look, you are the people you're taking away our lands. You are the one who are making us leave our lands. So this has been a strong issue that we're all fighting against. We who defend the land, we who defend our territories, the water. So justice must to be applied, because justice in Mexico truly is not applied. Destruction is happening, or the environment is in vogue, and there we are, right in the middle. So me and my sisters here, many colleagues from other countries, we're all from little villages or rural areas, so we suffer the consequences of this justice system not applicable. And that is in the agreements, in treaties, but they're not exerted. That's it. Thank you. Very well. I also wanted to mention also that on this topic itself, starting from the consolidation of a new republican states, indigenous justice has to coexist with ordinary justice. Now, with the disadvantage that ordinary justice is sponsored by the state itself and strengthened by it. In the indigenous justice, we are minimized now. That's how we feel, even subordinated before the ordinary justice system, because this ordinary justice systems have mechanisms, economic support from the state, and we, indigenous nations, are only can exert according to our own capabilities, that's it. But if these capacities or capabilities have been limited by the state itself, under laws and with strengthening the ordinary justice system and the lack of knowledge of the justice operators or ordinary justice who do not understand the indigenous nations' justice system, I think we are running a huge risk here. Indigenous forums, for example, if we do not apply the same dimension that we have had in our own territories, we will die out, because we have controlled our territory and our people with our own justice system. But if we're not exerted in plenitude, I think soon enough we would say that these indigenous peoples have transformed themselves or have disappeared in time. So therefore it's important that this event itself can recommend that not only here from governments but also from the indigenous peoples ourselves, we have to fight. We've been resisting for a long time, and now it's time that we apply action on this, brothers and sisters. Thank you very much, ladies and gentlemen, for your comments here on each topic mentioned within these three tables. In this sense, we give the floor now to Hector, who has a couple of brief comments to make right now. Thank you. Well, we are very clear that during the last declaration of the United Nations and the declaration of South American nations, we have to talk about our autonomy and our free determination. And starting from there, it's a crucial part of our states. How we can negotiate with other states and our own legal entities within each of our states. Unfortunately, the reality is not the same in all countries of the Americas. However, that would be the dream. In the case of Panama, I will reflect on that we have a territorial division. We have a traditional government which dictates in the area. And we are right now checking trying to implement an indigenous court. I participated on access to justice here in Panama, but we went through that we have to reinforce and strengthen our institutionality as indigenous peoples. A second aspect on justice is justice, unfortunately, is not the same in all places. So therefore, as our colleague says, the majority of us, we are victims of capitalism. Capitalism, what it brings with us is mass tourism, extractive industries, and truly, not all courts in all countries is a great example. We have had up to now, in certain cases, we've seen some, but an important thing, though, something that we have to fight against as indigenous peoples, and here I'm calling the attention of the lack of indigenous peoples. We also, as we have defenders of human rights and lawyers and indigenous lawyers or indigenous defenders, unfortunately the majority of our lawyers graduate in universities colonizing universities, as our colleague from Peru says. So they have this idea and they have different point of view. It's happened to me that as an indigenous lawyer, I've been told I've been crazy, but no, that's the training that's a lawyer has these days. Now the last discussion here, excuse me, is the Supreme Court of the Americas. About 20 years ago, this was thanks to Victor Hugo from Bolivia, who was vice president back then. He met he gathered indigenous lawyers in Sucre, and we started talking about this issue of indigenous rights. But it was left. They left it just like that. They abandoned it because it was financed by the. They abandoned this topic, and up to now, we haven't got back to it. But many of our countries, our courts also only see what they do, and they don't see what other states do. It's important because Supreme Courts of Justice in our countries believe like they are like the untouchables. So they don't realize that other states, for example, in other countries, a lot has evolved on access to justice of indigenous peoples. And they call compared justice. In many countries, they don't use this. At a level of our legal system, it's compared system, how to decide and how this is received in, how we decide this in North, Central, and South America. So that's why it's important. It is important. An event as such is so important to, therefore, to create some sort of network to follow up and monitor all these issues, which to me are fundamental and are issues of life and death. If in some of our peoples here, it is truly an issue of life and death. I'd like to thank you once again, ladies and gentlemen, for your comments, your contributions. This such a rich discussion, which truly will lead us, or will mean, let's hope to mean, progress, important progress and advances for our peoples. Now, in this sense, we will continue with the following session. Thank you very much. Once again, thank you very much, ladies and gentlemen, for participating in this discussion. Very well, so now we are beginning now the intermediate meeting called Vision of the Indigenous Youth on Access to Justice of Indigenous Peoples within the region. So now we will introduce our distinguished panelists, and we ask them to please take your seats. Mr. Cali, or narrator on Indigenous Peoples' Rights, Ms. Felicia Ibarra, she's ACNUD in Bolivia, representative of OACDH in Bolivia, Ms. Mallorca, she's also from Costa Rica of the OACDH, and Anexa Alfred, member of the Expert Mechanism on Indigenous Peoples. The debate and moderation of this will be in charge by Marcelino Villegas from Bolivia. You have the floor, sir. We have 1 hour for this roundtable. Thank you. Good afternoon. Much gratitude for giving us this space, and especially soon that we're, well, I'm sorry for being so soon because the lunch is up and coming. So thank you for your attention. We'd like to know what the Office of the High Commission is carrying out regarding the youth of indigenous peoples. Now, this space corresponds to how to learn about the vision of indigenous young people regarding access to justice within the region. It is important to mention that the Office of the High Commissioner of the United Nations has elaborated and initiated an interesting program in 1997. The program called Indigenous Scholarships. This program has 3 main purposes. First is that leaders and indigenous authorities can participate and deepen their knowledge in 3 areas. One is the international system of human rights, particularly from the United Nations and or other systems. 2, that these participants also must learn about the mechanisms or the treaties and entities. And thirdly, that networks can be created of leaders and indigenous and authorities as well together. Under this premise, our guests at the moment know about this role, and therefore from this perspective will share their experiences. Thank you. We give the floor now, first of all, to our rapporteur, who we know already, so he can share his perspectives on the following question. Mr. Rapporteur, from your experience, what is the role of young Indigenous youth regarding access to the Indigenous justice system within the region? Good afternoon, ladies and gentlemen. I think that here, representing the youth, a crude youth, let's say, I'm very happy to see that the organizers have dedicated a certain space to this such important topic. Because as always I've said, the young people are not just the future, if not they are also the present. It's crucial that always they may have a space to share ideas in all forums, in the decision-making process, so their voice can be heard in the creation of future public policies or policies. In fact, I was telling one of the organizers that it's unfortunate, somehow or another, that only 1 hour has been taken. 1 hour when we're already tired. Because it's a lot of information being shared here. And this morning, for example. And that has happened always. Young people are always left aside. And I think it's necessary that we actually give them that importance, that space. Indigenous youth have shown to be agents of change in many things, in many issues. For example, my report for 2021 of the impact of COVID-19 in Indigenous people dedicates special section to the actions and activities carried out by young people to mitigate negative impacts of COVID-19. Amongst these, we include the vitalization of cultures and indigenous languages, the use of indigenous medicine, and the use of art as a means to communicate the risk of contagion or infection. My report 2002 and our role of women in the mitigation, preservation, and acknowledgement of indigenous science and technology mentions the role of young people and young women in applying their indigenous knowledge in many areas, in farming up to the preservation of biodiversity. Regarding the area of justice and access to justice, young indigenous people play an important role in the maintenance, preservation, and transformation of legal system, justice system, and indigenous law. So you must establish intergenerational discussions, because the elders, indigenous elders, are the key of cultures, of values, and cosmovisions on issues of justice and institutions of indigenous people. Therefore, it's fundamental to create these spaces to promote the intergenerational communication and dialogue. Indigenous youth have a great knowledge of the means of communication these days and of technologies which may be used to promote initiatives of preservation of legal knowledge, recovery of their own indigenous institutions, and encourage learning, amongst many other things, education. So I'm just going to leave aside my words here, and I'm going to tell you something from my heart. Now, listening to the previous panel, which has a lot to do with young people, of course, it just reminded me of something. Our brother Hector mentioned this as well. A while ago, around the 80s or 90s, when in the United States they were trying to make the Yaqui to be recognized. They were trying to recognize the Yaqui tribe in Arizona, and who was promoting this situation when the Yaqui tribe was recognized? He said, yes, okay, great. The state has been attacking us with firearms, and they nearly exterminated us. Now they're going to try to attack us with laws, with whatever is necessary to send our young people to universities so they can turn into lawyers. The only problem that we have right now will be, or the problem that we will face right now will be, that we're going to have very good lawyers, but not good Yaquis. So what they did was last year, if I remember well, the Yaquis signed an agreement with the University of Arizona to start to themselves to direct and us to direct a segment or a part of the University of Arizona to be in charge of it themselves. So they said, starting from now, we will have good Yaquis because they will have the support from the community with our culture, but also we will have good academics because they will be all programs will be directed starting from the Yaqui culture. So what I'm trying to say with this is that now it all depends on the indigenous peoples and communities. We have progressed very much. Everything that we have up to now has not been free of charge. It hasn't been a gift from the states. No, it's the result of the struggle of our forefathers, our forebearers. This year, it's going to be 100 years from the presence of the first indigenous diplomat in Geneva, which was called the head of Iskahin, the chief of Iskahin. Imagine that, chief of Iskahin. After Descachen is the degree of diplomacy that that you have. It's not that he was called Descache, no. Descache is the degree of diplomacy given. It's a title given to people who speak on behalf of their own peoples in the Iroquois nation. So now it's going to be 100 years. 100 years. And up to now, we have a declaration, a permanent forum, a mechanism of experts, and we have also special rapporteurs. We don't know the results yet, but there's still time for this. So that's why I'm saying that young people are the present, the future, and they have an utmost important role to play starting from these experiences. So I've got the red card now, so I must quiet my words. Thank you very much.
Mr. Rapporteur, our gratitude for your words. I would like to accurate that yes, it's true that the previous block, that was the consolidation of the works of the table, the academia moves forward until that point, and sometimes from that perspective, well, all universities, and that is usually an obstacle, and so that's why it's interesting that the role of the indigenous youth goes beyond to generate spaces of interculturality, and hopefully those scenarios can also happen from the supporters of the High Commissioner of the United Nations. So please, let's go to our colleague and member Cristina Mayorga. I will introduce her. And so she's a lawyer, specialist in human rights and the rights for the indigenous people, has worked as a consultant in the National Committee, but also in UNESCO. Indigenous with experience in education, local education, and was a legal advisor of the education guidance in her people. Please, sister, we give you the microphone with the next question, the following question. From your experience, what are the action lines that can address the role, improve the role of the technical assistance, of the role of the High National Assistance of the United Nations with access to justice for indigenous people? Good morning. I feel very happy and grateful to be here. Ana Bibri, Indigenous from the Indigenous community Talamanca. Regarding the question, I want to say that I believe it is a role that has been performed by the United Nations with these programs of scholarships. But I do think that the United Nations, the High Commissioner of the United Nations, should in their countries where they are located have more personal, indigenous personal. I say this because of my experience. We were just two indigenous people, and I think that speaking about access to justice must take into consideration the knowledge from the indigenous people, from the territories. If we speak about access to justice, as we have been developing, we cannot speak about access to justice from top to bottom. We need to start from our territories towards the institutions. What does that mean? So, with this topic of access to justice for young people, there should be a transversalization of justice, intergenerational justice, but always taking into account the knowledge of the elderly in the communities. In my culture, for instance, for us, Bribris indigenous people, knowledge of elder people are extremely important. Me, as a lawyer, I always go to an elder person to ask and tell and ask how to apply this regulation or an article and how to interpret this article and specify this for a resolution. It is not it's not taking what we've learned in the academia and go and say this is what we need to do, right? It is always thinking about the basis of our knowledge, but I consider that the United Nations and the High Commission in their programs should also develop specific topics for access to justice for indigenous women. There's a resolution number 39, that speaks about access to justice for indigenous women, but indigenous children also, girls. And we as indigenous women, we need to be reflected on that. Apart from that, as a senior scholar, I can also say that from my experience, we have also collaborated quite a lot with providing our knowledge from our culture. We were seeing the presentation from the magistrate, Damares Varga, from Costa Rica. There was a support, some from my perspective as indigenous woman, and also the knowledge regarding the traditional knowledge of our indigenous culture, taking into consideration that we have 24 indigenous territories in Costa Rica, and all of them with specificities. What is the line of action that should be implemented? These programs should be more sustainable in time, meaning that the scholars that leave the High Commission continue to be the ones that channelize all of these processes that we have learned, but also coming from the institutionality, meaning taking into consideration a process, a consultation process, a public policy process, institutional process that takes into consideration the specific voices of indigenous people. I'd like to summarize by saying, and I said that that's why we need to start from the basis and not from the institutionality. And this is something that we need to view in different environments, in the public institution, but also international organisms. It was said by the special rapporteur, so much time happened, so much time passed to have a first indigenous representative, and many times this happens in the countries. We do not have a representation that is active and proactive in the institution that can say how to perform the processes, justice processes in this case, in indigenous territory, always taking into consideration the word and the knowledge from the senior, from the elderly. I think we also need to implement within that line the vision of the youth. Why? Or the perspective of the youth. Because many times they are the change agents, the young people are the change agents, but since it's not taken into consideration, their perspective are not taken into account in this processes of action of access to justice. As young people, we all indigenous people are recognized internationally and all the international standards. And in that sense, I believe that from the beginning, yes, some work has been done, and this work for the people here has us sitting on those in these tables, and I do think that this is the line that we need to follow, but must be sustainable throughout time in the countries, because as a scholar, and many scholars, to say it somehow, get lost in space and do not consolidate themselves in this sense. So this is something that we need to do. We need to consolidate in our countries and territories. Thank you so much, sister. Please, if you allow me, to emphasize the role of the youth to highlight the elements of the intervention, the knowledge of the territory, interculturality, included for the works in human rights, the language, because in the communities it's fundamental to know about the organizational systems, among others. And secondly, the sister was mentioning about the role of the indigenous women in the labor, in the work in these territories. These are two elements added to a purpose that this event is looking for, to have work alignment processes for the High Commission that makes operational this focus to the territories. Now we'll present Sister Felicidad Ibarra, indigenous woman and an activist, expert in human rights and rights of indigenous people, a social communicator, and now senior in the Office of Human Rights in Bolivia. We will ask her what are the practices that you could highlight from your experience for the work with the High Commission work about access to justice for the indigenous people from the territories. Please go ahead, sister. Good morning once again to all. To respond directly to the question, something that maybe I can highlight is that you can't work, for instance, in this case, if we're speaking about indigenous justice, without the indigenous people. Well, if there's a mandate, and that is as a moral mandate, as a moral obligation, something that where most of the people that have been fellows from the High Commission of the United Nations, is that you have the obligation, moral obligation, and a personal obligation, since you are in this territory, to visibilize the lacks, the things that are missing in the different people. And in this case, from this environment, what I have seen, what I have been visualizing, is that the High Commission can work directly with those executing and applying indigenous justice, and that is with the indigenous authorities from different territories. That approach. And if the High Commission does not go to the field where the authorities are, where they execute and apply indigenous justice, it's going to be very difficult to understand. So what we agree upon is that from the High Commission, the office can have that incidence, can go to the field, see the reality, know about the context, and from there to raise documentation, systematization, and from there to strengthen when thinking about global standards and human rights. And that is also thinking that the execution of indigenous justice, it's not necessarily something that only involves people in the territory, but the territory itself. So what has been done is also visualizing this. And the key thing that the office has been able to view is that it is extremely important having coordination with the different organisms from the state, with the legal organization, with the legal organism, to work in this complementarity framework, to coordinate with the high authorities, not only from the ordinary jurisdiction, but also indigenous originary jurisdiction in this case. How to strengthen? Well, basically, in that approach, in that visualization of what's missing and lacking and the needs that the indigenous jurisdiction has, and how this should coordinate, and how this mutual cooperation should exist between the different jurisdictions, right? So there's an incidence on this topic from previous years. Likewise, it's when thinking about the knowledge from the fellows from there and this coordination among the authorities, this is also something that is happening, which is the strengthening directly to the different territories. It's useful to say in a holistic way, in an integral way, with different indigenous jurisdiction. Speaking about this jurisdiction, indigenous jurisdiction is not just one. Remember that we have several justice systems in indigenous people, so it varies quite a lot, the situation or how it is executed, the application of justice from one territory to another. And even the office, I would say, what they're doing is to integrate and has been learning to act. It needs to prove directly, demonstrate that interconnection, that interculturality. Let's not forget that many people, those working in the United Nations, have different nationalities, and knowing and learning about the richness of the different places does so much to support and strengthen according to it. And something that I've seen in this case, something that I would like to highlight, it is the strengthening with criminal or penal execution judges. Much has been said because within the penitentiary centers, there are many people deprived from freedom from the indigenous jurisdiction. They basically don't even know what is the legal situation they're in, because they haven't even had translators or interpreters for these people to know what their legal situation is, and the time they've been even being deprived, detained, preventive detention, and they haven't had this execution of the law. So these are factors that they have endured, but from this coordination with these indigenous authorities, they are the ones that have started to say, okay, we have indigenous people that have been sentenced, that have been, or they are in the ordinary jurisdiction or in the criminal center, and we can't take them out. When we do follow up, what we visualize is that most of them, these are women deprived from freedom, indigenous women that are in many centers. So that makes us see and visualize, makes us think about that work that is left aside. No one has given the real importance to this. So that type of incidences would not happen if you don't have an incidence, if you're not directly speaking constantly that you need to strengthen the indigenous jurisdiction, but with real concrete facts, not only on the speech, but truly have an incidence that this should be done on the field and in that constant coordination. Thank you. Thank you for this space. Once again, maybe I would like to highlight this, which I believe is fundamental. Indigenous women deprived of liberty, of freedom, what happens to them? What happens to them in a jurisdictional hemonism system? What are the levels of the application of the standards of the rights of indigenous women in this environment? But also, these experiences of coordinating with the indigenous authorities, which are the decision makers in the jurisdiction, it's a very important challenge for the United Nations system. Please allow me to thank our speakers. Please, and go to your seats now. Now we have another colleague that unfortunately was not able to get to Chile for different reasons, but she is an ex-fellow and now member of one of the mechanisms from the United Nations. We would like to have a Zoom connection. I think it's ready. People on the technical assistance communication room. Yes, to hear her, please. I introduce our sister, Anexa Alfred. She is an indigenous lawyer from Nicaragua, advocate of human rights of indigenous people, originary from the community Huapi, and has been a member of this program that we talked about for education of leaders and indigenous representatives, and as I said, member of one of the very important mechanisms from the United Nations. Please, sister, go ahead. Good morning, good afternoon, or good evening, in my case. First of all, I would like to present my regards to those who have been before me and the members of and the people, the scholars that have spoken about the role of the jurisprudence and the process of access to justice. I'm having some issues. Just give me 1 second. I think there it goes. I think it's better, yes. First, my dear regards and my friendly regards. Unfortunately, because of very important reasons, I was not able to be there, but to me it's an honor to speak with you through the distance remotely. But I have joined you, I have been joining you in this very important dialogue process. I was asked to speak about some concrete actions to improve the technical support from the Office of the High Commission for Human Rights of access to justice for indigenous people. I think it's important to highlight that some concrete actions that we see fruits, we see the results, has been the use of the program in concrete terms. We've had access to this program, many young people leading in different parts of the world considers that has had a fundamental impact. In some cases, it's been of a high relevance. I would like to take a minute to take a tour. In my case, I also started with education processes, these programs, and it's important to highlight the affirmative actions that can be taken in the benefit, well, not in benefit, but in order to have equal access to the spaces that allow to have access to justice for indigenous people, and especially the role that you may have. Maybe it was not said, but I work for the Inter-American Commission of Human Rights. Actually, I'm the first indigenous lawyer working in the Secretary of the Inter-American Commission. And I make this, I mention this because it is related to a scholarship program from the OAI program that gave me this opportunity to enter the program. Years later, I work in some programs to limit the lands in Nicaragua, a process with no precedents that, well, however, we still have big problems in terms of the restitution of the rights in an effective way. I was senior fellow in the Office of the High Commission in 2007. I had the pleasure to share with some of the members there present, and that is also something that gave me the opportunity to know about the system from within. Even though it's true, I had some studies related to the theory and knowledge coming from the basis of the community, but to know the system from within is extremely important and puts us in a position of being able to help in a more effective way with our people, with the communities. So I think that some of the concrete actions continue to be to keep programs such as this and a holistic program that provides not only the vision from the point of view of the theory, but the practice, but also learning all of the strategies that might be used for the advocacy. Oh, working locally, it's also very important. So it's been key the step you've given to develop the program through senior programs on a country level. And today we can see the fruits of it through this excellent activity that they are performing, the seniors. But a big aspect that I think is really important that we need to keep in mind to move forward in access to justice, all actions that will be taken over must be conveyed in the declarations uh, in the Declaration of Rights for Indigenous people. It must be the minimum standard for the conception of individual and collective rights of Indigenous people in the Constitution. In that sense, it's really important to keep in mind mechanisms that exist for justice access in terms of specific mechanisms that exist in the United Nations systems. We know that everything related to indigenous people, the mechanisms of the rapporteuring of the indigenous people, the express mechanisms for the rights of indigenous people, the permanent forum, but different mechanisms that exist. The treaties mechanisms that more and more well, they play a key, must have a fundamental role, predominant role on these mechanisms. So, decisions of a coercive environment, and we have received the tools in order to participate from the revisions of the treaties mechanisms and also the universal periodical test, the exam, and in the Council of Human Rights. Personally, to me, it is an honor, and I'm very happy to see more and more the participation of more young people in these mechanisms. Not only the forums, the traditional forums, but the mechanisms of treaties of rights, but also the Council for Human Rights. One of the other factors that I'd like to specify that I believe is extremely important is for the office to move forward, not only in keeping these mechanisms that have been the result of a great work of incidents of indigenous people. I said it before, the rapporteur said it. Mr. Calixa, over 100 years of a fight, a struggle from the diplomacy in order to create these mechanisms that today are available, better yet, for the defense of the rights of indigenous people. It is also important to move forward in these mechanisms, not only formally, but also having spaces for people with experience, knowledge, and especially the commitment on being able to carry out a project with these mechanisms that are for indigenous people, but they have something specific. They are part of the process. Therefore, it is required having that commitment that more and more we see that the young people especially have. They have much experience, much capacity and knowledge that should be channelized with affirmative actions that allow to have a process of joining them on a longer term and not just specific issues. So I highly celebrate what's being carried out right now with the senior programs on a regional level, but I believe that we also need, well, in these affirmative actions that have been established in paper, they must be viewed, they must be performed, right? Now we can make a revision in the different spaces in the High Commission structure, and I'm sure that not even 1% of the indigenous people are working as any other person that would have this right. So also the issue of access to justice is related to how much space do we have so young people, women, and indigenous people can have access to be part of this structure, providing that plus that knowledge has traditional knowledge coming from the territories. And finally, I just want to say that another concrete actions which I believe we can implement and develop within the mandate of the experts mechanism. In the mandate, it is to provide technical support, specialized support to indigenous people, the states, and the different sectors. We always have the possibility to collaborate and to develop specific programs and policies that allows us to move forward in the compliance of what the declaration states regarding the rights of human people or of indigenous people. So my vision is related to this, and of course I'm always happy to share a Q&A session with you. Thank you so much.
On these things, the role of the youth, on how we're participating within the system of the United Nations, and how also this fellowship program is also contributing to something fundamental like the access to justice. Please, this is an open dialogue, open discussion. We'd love to hear your words, and if you need the microphone, just raise your hand, and our colleagues will help pass it on to you. Thank you very much. Now, regarding what was mentioned just now, I think was mentioned by the special rapporteur. It's important how we encourage from our own processes or organizational processes the training on our own rights. And we cannot expect that the university or external universities actually train us to do this. We, from our autonomous exercise that we have, I believe that we can progress. There are examples in other countries, in fact, with other brother and sister nations, where exercises of training programs have been carried out in their own rights, in our own law. For many rights, for a long time, we've done this, and we have gone. Men and women has passed through this training program to understand the laws of our own peoples, and therefore acknowledging that we can help others nations exerting their own rights. It's a motivation which is important. Sometimes exchanging experiences are very positive to learn where we have progress on this and things that will allow us to exchange information and take to know other people, other indigenous nations, because it's a way of communicating and exercising together. So it is important the role of young people and women as well, because young people or youth and women, I would say, unfortunately, they're very much aside from all these exercises within the communities themselves. We are very much left aside. So we have to look from the outside to the inside. It's not about decolonizing or getting rid of this patriarchy, but when we do not see the importance and the participation of women and young people within our own indigenous communities, and that dangers the feasibility of nations. So it's important also to value what is the role. What is the role of the youth? What is the role of women? Which surely was a different role before, maybe, before that these changes and transformed our own customs and ideas, and now we're starting to recognize and value the role a bit more of women now. There's a concern. I do not know whether maybe in nations here present it's happened to you, but in our case, in the case of Colombia, the constitution does not recognize the exercise of justice, and this has been carried out and it's been very important. Nevertheless, currently we have a situation within which made us think and consider. We have been recognized and we do this, but it seems that we're not doing things properly. Because in the case of the rights of women, now lately there's a sentence where the court invites to review how our indigenous authorities are carrying out justice, because it seems that justice is not being made. If not, it's been all about re-victimization, there's impunity. So we ask ourselves once again then, so what are we doing therefore? I believe that this is a concern which indigenous women, well, it's in our minds lately, because we're feeling that within our communities we have this void, and we do need to strengthen this amongst all of us. We regard this with concern, because exercise of justice are not being carried out as it should inside our communities, and that's giving space to ordinary law to question our own indigenous laws and rights. And it's a shame, because we've gained a lot in these activities and in this struggle. Thank you. Thank you very much. Good morning, ladies and gentlemen. I want to refer to myself very quickly on this topic. Even though it's important to strengthen the role of young people in the access to justice, nevertheless, I do believe that goes a lot through what we can do in each of our states. In the case of Ecuador, we have a constitutional important constitutional process, sentences from the constitutional courts, very important. In fact, we have an ex-magistrate here present who has ordered some very good sentences. Other magistrates who, within their own functions, and have contributed very much so for their jurisprudential progress on the rights of on indigenous peoples. The thing is that we have many constitutional tools and instruments, these sentences. Nevertheless, problems still persist within communities, especially the issue of, in our countries, subordination continues of indigenous justice by ordinary justice. In other words, there's no experiences of a true coordination and cooperation between both systems. We, in the case of Ecuador, have the figure of declination of competences, which means that if a case or a conflict or dispute has occurred within the community, and that case is being resolved by the indigenous authorities, the same case is in the ordinary legal system. The authorities of the communities can tell the ordinary law or the ordinary justice authority not to continue their procedures because it corresponds to them. Nevertheless, they don't take notice. They don't take any notice. In fact, there's a constant fight and struggle between the indigenous authorities and ordinary justice, because indigenous authorities, they have to carry out a whole procedure, torturous procedures, even though they're under the regulation says it's a very simple procedure. Nevertheless, unfortunately, in certain occasions, ordinary judges request until you show, you demonstrate, you can prove that you're indigenous authorities, or that you're even indigenous people, and then they're judging us on different things, even in both institutions or both authorities. And these actions obviously end up delegitimizing the actions of the indigenous authorities. Therefore, how do young people see that? Well, it's recognized. So what's for? What do we have? Indigenous authority or justice? What's it for if the ordinary justice or the judge did not recognize this? Now, Agreement 169 makes possible the interpretation of intercultural peoples. So that means that indigenous peoples who are submitted under this process have the ability of sanction according to their own cultural reality. But in the case of Ecuador, even though there is a sentence from the same constitutional courts, ordinary judges don't take any notice of it. So therefore, we do need public policies. We do need tasks, and I'm saying that from these spaces, these sort of events, so ordinary judges truly take seriously this issue and can contribute towards that plurinational nation, which is within the constitution of the country, but unfortunately, in practice, it's not really given. In this sense, I believe that yes, we must work very much so to truly so the young people can be interested in this and they can contribute in this role. But we do need also a lot of work. The other regarding women, we in the case of Ecuador, we are working very much so on strengthening the governments, so the community governments, understanding that community governments do have the ability and the exercise of rights of autonomy as well, and the right of autonomy to assume that a regulative and jurisdictional figure. And starting from here, also we are working on reforms of the Constitutional Carta Magna or the statutes, including this fundamental element, which is the participation and the visibilization of those issues which affect women, young people, children, adults, who also should be considered within the Indigenous justice administration system. That's the issue, that many organisms say, or entities say that, oh, Indigenous law do not resolve issues that afflict women and young people. But that's it. Thank you. Thank you very much, sister. Thank you very much. My contribution is related to also the aspect of young people, indigenous young people. Currently, I am at the border. Well, right at the edge. I'm not in that category anymore. But my professional career truly, I began at 26, 27 years old, teaching. And I was facing an interesting challenge, which today, reflecting on it, it seems to be, currently I wouldn't do the same, but it seems to be quite an issue. Now, back then, I was facing myself to this dilemma. So I prepared myself. I had the ability to study in Italy. I obtained my master's degree, but this was an international issue. Now, a general line that happened throughout my schooling was how I contribute with the Quichua people, my nation, my indigenous nation. The opportunities that rose was to go to Quito, to leave the country, to go to find other spaces. However, for me, it was problematic because all the time that I invested in training, studying, will lead to processes which had little or had nothing to do or limited to do with my reality. In that sense, for young indigenous peoples, I do consider at least the process of training and education, it is a real issue to break community ties, to find spaces which lead us to break these community ties. Now that the task that from indigenous young youth groups are carrying out is very important, because from activism, from the propagation of information, we are viewing these issues, we're generating dialogue, but at the moment when we have to actually make these things economic and labor-wise, we have to make all of this sustainable, and we need to migrate. We have to leave the cities or leave the country. So I was lucky enough to have the opportunity to work in different territories. Currently, I am a teacher at the University of Otavalo. Nevertheless, that's where another debate arose, because what's my role there as a professional? To promote the rights of my community. At least in Ecuador, research is helping us very much so. Research has helped us to visibilize, to disseminate and involve professionals who respond to the needs of indigenous peoples in the University of Otavalo. In fact, until last year, unfortunately, these processes are influenced by the market, of course. What does the market need? What does it want? What type of professional does the market want? We encouraged legal pluralism and indigenous justice. We had Quechua language within the curricula, but the market, with their aggressiveness, with their criteria, have made it impossible to continue these processes. And currently, unfortunately, we are obliged to halt our processes. Nevertheless, to involve indigenous young people from universities, their involvement, together we must define professional careers, their roles, their ethics, their morale, and their functions within these collective functions. Sorry. Another interesting thing is that it seems necessary to touch is on how we, young people, are involved in the processes of indigenous justice. At least at a territorial level, we have seen certain issues and problems. Let's think about sexual diversity issues within communities, aggressions on behalf of the communities themselves towards these spaces which before were not visible even. And in fact, a sort of persecution for these types of situations. Indigenous justice, maybe it might need to reflect or have a vision of issues that actually involve us in current days, which maybe were not visible before, but we do need to make visible currently. Recently, indigenous justice that carries out cases on Bitcoin's hoaxes or issues. We need helping hands, allies and partners, because this is a whole process which we can't do it alone. We need help, coordination, and do things together. Thank you very much for your participation. So, thanking beforehand, allow me to summarize 3 elements here, which sometimes point out a lot of your words. First of all, the participation of we have to think from our organizations also, that was a reflection, a perspective on how we are decolonizing ourselves. I think this element could be important for all challenges that will come from this event. Secondly, subordination of justice as an element which gives little faith for the young people. They sort of think, well, there you go, it's in the constitution, but it seems that it's not fulfilled, it's not complied with, or there's something to work on. At a level of public policies, a third element, I believe the most fundamental, in fact, how we unite the modern state with the territories of indigenous nations and peoples, and therefore the concept of public policies will be fundamentals. Thirdly, our colleague here, our brother, was talking about teaching. How is the education, how it's being understood by the academic world as well, and what would be the contributions from that space itself? Unfortunately, because I've had 2 red cards now, past my time, but I'd like to thank everyone, nevertheless, for your contribution, and I'll give the floor to my colleague Pedro to continue. Thank you very much. Thank you, Marcelino. Thank you, everyone, for your contribution and your words. Very well, so now we go to an important part of our event. We're going to have an official photograph. The official photograph, which will be, this will be carried out on the first floor, if you will be taking this photograph. Afterwards, we will go for lunch. That's another important part of the session of today. And we hope that everyone back here at 3 o'clock on the dot. So thank you very much and enjoy your lunch. Oh, our colleagues will be outside here to let you know where we're going to take this photograph. Also, we invite you, for those who have not entered our WhatsApp group, where we're all sharing information, and we can ask our colleagues here to share the QR code on the screen so you can enter this WhatsApp group. And we will see you back here, therefore, at 15 hours, 3 o'clock sharp. Thank you very much.
afternoon, ladies and gentlemen. So we invite you to take a seat to start the next session. Very good. So once more, good afternoon. Welcome back. Hopefully you have enjoyed a very, very nice lunch and you have a lot of energy to continue with our agenda. We have some reports before starting the next session, because next session will be in English, and I invite you, if you require for simultaneous translation devices, they are outside of the room. So if you need translation, please go and pick them up outside the room. Once more, I invite you to enter to our WhatsApp group. It's on the screen, the QR code, and we will share information about the event and also the pictures we have taken, and we will share the pictures from today's session. From now on, we are coming back with the virtual broadcasting, and without further more, we will start with the second block. This is a session focused on right to land, territory, and resources, and access to justice. In this follow-up, we will have the honor of listening the lecture on this very crucial topic for this event and for all of us, so we ask for the attendance of Mr. Ramiro Avila and the expert Kate Harper. The moderation of this lecture will be performed by Mr. Ramiro. You have the microphone, Ramiro. Thank you. Thank you so much. Thank you so much. Good afternoon to everybody. It is to me a huge honor to present Mr. Kate Harper and his lecture that comes now. Kate Harper has a curriculum that is amazing. He is a citizen from the Cherokee Nation, has fulfilled roles such as the advocate, academic, and also a public officer. As an advocate, he is president of the Indigenous Buffet, American Indigenous Buffet, and co-president from the Office of Human Rights and Global Strategy. He also has represented a group of 500,000 complainants for indigenous people and acted as a lawyer in the group in the historical trial of financial Indian funds, where there was a negotiation of an agreement of $3,400 million. As an academic, Mr. Harper has been a professor in Merit Cathedric professor in the International Policy Institute, and also has taught indigenous law, federal law, in the Faculty of Law from Universidad Catholic University of Columbus and the American University in Washington. As a public officer, Mr. Richard has been an ambassador from the U.S., permanent representative with the Council of Human Rights of the United Nations in Geneva, has also been a commissary of the Presidential Commission from the White House, a member of the transition team of the presidential Obama-Biden in the Energy Group and Environment Group, has also been a judge from the Supreme Court of Porch Band of Indigenous Creek and Judge of Appeal of the Tribal Michal Tuket Pecas Court. With that information, I am certain that the keynote speech he will provide, there's no one better than him to provide this lecture, named The Right to Territory and Resources and Access to Justice. The modality is 20 minutes lecture, and the remaining time will be for a dialogue and questions and a discussion from the audience. Mr. Richard, it's such an honor to have you here. Mr. Harper.
To be with you today, let me thank the OHCHR and those who worked very hard to convene this gathering, this important conversation on Indigenous rights at the 75th anniversary of the Universal Declaration. I do want to take a moment to talk a little bit about the Universal Declaration, because I think that often we overlook some things about it. First of all, one thing we need to recognize, because we think that these idea of universal rights, of human rights, international rights, am I going too fast?
Por favor, ¿se pueden comunicar en qué canal están torciendo, por favor? En el canal 1, por favor, las personas de habla hispana, está la traducción del inglés al español. Al portugués, por favor, ¿qué canal? 3. Canal 1 al español, canal 3 al portugués.
Can I go? Okay. So I did want to take a moment to talk a little bit about the Universal Declaration, because we sort of that's okay.
No está funcionando, por favor. ¿En qué idioma no está funcionando?
I'm sorry, it's not working. They're trying to connect.
En español. Si las traductoras, por favor, pueden decir algo para ver si se escucha en los receptores. ¿Se escucha? No. En el 1, por favor, si nos dan señales de que cuando se escuche. Por si acaso hay que prender el aparato.
In English, can you hear me in English? In English, can you hear me in English? And in English, you can hear me. Y en español. Entonces vamos en el mismo canal. Canal número 1 para inglés y español. Canal número 1 para inglés y español, entonces.
Perfecto, estamos. Ok, continuamos.
Okay, so we'll continue. Mil disculpas. No, no hay problema. Muchísimas gracias. Y bueno, todos hablan en español y yo soy como la única persona que habla en inglés. Agradezco muchísimo todos los esfuerzos.
or any other type of division for the first time. And that's why we celebrate it. Not because it was the end-all be-all, but precisely because it started a process by which the international community said that because of human dignity, every state owes a set of obligations to all individuals. But even at the inception of the Declaration, there was a recognition that this was the start, but that much more had to be done. And so out of it, and later we had a covenant on civil and political rights and economic, social, and cultural rights, and elimination of racial discrimination, and one on women, and one on children, and one against torture, among many others. Because it's an ongoing conversation, recognizing that it changes over time and is going to become more inclusive over time. And the most recent vintage, or of the many recent vintages, is Indigenous peoples. A conversation that was 4 decades in the making, a discussion between Indigenous peoples and states within the confines of the United Nations to understand what are the rights of Indigenous peoples. What should we agree to? What are the expectations of states? What are the things that Indigenous peoples can rely on as the things owed to them as rights for their land, their territories, their autonomy, their decision-making, all of it. And that is what the Declaration represents. And little less than a decade ago, it was universally accepted because there were some states, including the United States, that did not accept it at first, and now essentially universally accepted. So, you know, the other thing I want to point out is for those who talk about the Declaration, and some do, that it's merely a declaration. Remember, the Universal Declaration is merely a declaration. But we celebrate it this year because of the power and the impact that it has had in having states comply with its dictates. And that does not mean that all states at all times comply. In fact, there is no state without human rights issues. But now we have the settled expectation, so we know what the measuring stick is. And the human rights conversation is about establishing normative frameworks so we understand what the measuring stick is. One of the things, I have written comments, but I am going to diverge from those in times because I heard a lot of very interesting, intriguing, and important discussion here today. And when we talk about the topics of access to justice, one of the things that I think we need to think about is precisely what do we mean by that? What do we mean by access to justice? First, let's talk about what are laws. Laws are merely agreements by states of rules that dictate outcomes in juridical tribunals. That's what laws are. So you have a law against stealing from one person to the other. You have a criminal prosecution. If they get prosecuted, they serve time where they pay a fine or whatever. You have lands, and you have a lease on that land for 5 years, and then you stay on the lease on the land after 5 years. That's a trespass. And so you have laws in most jurisdictions that talk about what happens with respect to that trespass. So laws are dictated outcomes for what occurs in the real world. Now, the reason I put it that way is because it helps us understand a couple of concepts. First of all, whose laws are they? Whose laws are they? Who writes the laws? Who enforces the laws? I remember our esteemed special rapporteur earlier today talked about the importance of understanding the many different legal systems, indigenous legal systems, non-indigenous legal systems in the Americas. And it's very important to think about it in those terms, because those different legal systems create different laws. Because what are laws? Laws are rules that reflect values, interests, negotiations among various peoples that are then imposed or enforced against those peoples. And it's helpful in my mind to extrapolate all of these things because it helps us understand certain aspects of legal systems and what we mean by we say access to justice. And one of the things I think is very important, and one of the things that is accommodated by the Declaration of the Rights of Indigenous Peoples, is that different states and different indigenous peoples are going to have different structures based on their own traditions, customs, cultures, ways of life. their realities, and whatever the traditions are of the state in which those indigenous communities find themselves. And it's much easier to work with existing state institutions and understandings than to work against them. That doesn't mean that you cave to the dominant society, but it means you try to look at what is available and then utilize that effectively. So when I talk about access to justice, one of the things that we do in the United States, and this is not going to be true for everyone, is we've looked for ways to ensure that disputes that arise within tribal communities, within indigenous communities, don't go to non-tribal courts, but go to tribal courts, are adjudicated under the laws of the particular indigenous people. Those are called tribal courts in the United States. And the fight, if you look at the fight in the federal courts about, when we talk about issues of tribal sovereignty, it's about what do we get to adjudicate within our own tribal courts as opposed to what is adjudicated in non-tribal courts, the courts of the United States, the courts of various states, Oklahoma, Montana, various states in the United States. Each of these jurisdictions has different powers, different authorities, different jurisdictions. And the question is, who gets to decide what? But really, that's the central question of it all, isn't it? I mean, if you look at the Declaration, the central question of what the Declaration talks about is that indigenous peoples should decide on issues that affect their land, their people, their resources, their territories. Period, full stop. That is what it talks about. This is what the notion of free, prior, informed consent is all about, right? The idea that if it is going to affect the people, if it is going to affect the territory, the lands, the resources of the indigenous peoples, then they should have a role in giving free, so not coerced, prior, before the action occurs, informed, that they understand all the implications of whatever the project is, consent. Not consultation, consent. So to me, when we talk about access to justice, we have to talk first about where we're having access to. And maybe one of the places, and certainly one of the places in our experience in the United States that's worked, is to have access to tribal courts. To the extent that those are deciding the issues, then those are under tribal law. And so the laws that are created are based on that particular tribe's traditions, understandings, culture, values. And that is a type of access to justice. If you have a dispute, and it's on a tribal land, and it goes to a tribal court and under tribal law with tribal judges, then the likelihood that that dispute is going to be decided in a way consistent with the values and interests of indigenous communities goes up considerably. So the fight about sovereignty and who decides and what courts decides is a fight about access to justice. Now, there's a different fight about access to justice, and that is where you have disputes that arise in non-tribal courts. And the Declaration is clear on a number of fronts about what the expectations are of states. That states have to create, with consultation and in direct collaboration with indigenous peoples, fair structures to adjudicate their claims to lands, territories, and resources. That's what the Declaration says. And this brings me to another principal observation, having worked in the multilateral system on various levels, both on behalf of indigenous peoples, but also representing the United States. The multilateral system is a political system. It is not, first and foremost, a legal system. That's very important to recognize, I think, because I think many indigenous peoples go to the UN, the OAS. The OAS can be a little bit better, but at the end of the day, there's not a lot of enforcement authority. When you have a domestic, what happens in a domestic dispute? We call it hard law, right, as opposed to soft law. In a domestic dispute, two people have a dispute, the judge rules, you go through the appeals, there's a final judgment. And then you can enforce that judgment. You can seize property. In some cases, you can have seize bank accounts. You can seize land. You can get an injunction that forces them to do something. Get off of the land, clean up an oil spill, whatever the case may be. That is hard law because there is an ability to enforce it. In the multilateral system, by and large, even if a judgment goes against the state, it's hard to enforce that judgment. I mean, let's take it out of this particular context because I think sometimes it is easier to understand out of a particular context. There was a dispute in what's called the Taiwan Straits. This dispute is regarding who owns these waterways near China. And there was a dispute between the Philippines and China on the entire set of straits there, including the Taiwan Straits. And there was an agreed adjudicatory body by treaty that is supposed to settle those disputes. And it did. It said that the Philippines won. But China said, we're not going to recognize that decision. And we're still going to build these islands and take over that territory. That is soft law, ultimately, right? There's no ability to coerce compliance. And the reason I bring that up is because we need to understand that the multilateral system, as good as it can be, and I'm a fan of it, it is a political system. It is a way to push your domestic state to do the right thing. And there's mechanisms to do that. But at the end of the day, when you're talking about access to justice for lands, territories, and resources, they're going to be domestic adjudicatory bodies. They're going to be, by and large, with some exception, both courts within regions, courts of a state, or indigenous courts where they exist. And it's important to know because we have to understand where we can invest. As I talked about earlier, when we look at the Declaration answers a lot of the questions we have regarding territories, lands, and resources. Article 32 could not be more clear. It states that, quote, indigenous peoples have the right to determine and develop priorities and strategies in the development of use of their lands or territories and other resources, and that projects should not proceed without their free, prior, informed consent. Now that seems to me pretty straightforward. And if followed, I think many of the complaints that I hear about as serving with my good friend Rodrigo in the back there on the permanent forum, the ones that we hear about, are about failures to live up to Article 32. Because they're about actions taken without free, prior, informed consents on lands, resources, and territories impacting indigenous communities. And so much of our work, it seems to me, is to take these words on paper and figure out mechanisms to ensure that states not only follow them by word, but by deed. That is the task. In fact, it's always the task. It's the task of the Universal Declaration of Human Rights. It's the task of the political covenants. It's the task of virtually any human rights treaty, declaration, covenant, whatever you want to call it. It's about how do you take these words and bring life to them in reality. And too often they are recognized in the breach. where they don't happen. And the hard work of the special rapporteur and the expert mechanism, the rights of indigenous peoples, and indeed the permanent forum is about trying to give these international instruments political power to push states to do the right thing in example after example. And yet, everywhere, we see places where they don't work. Now, one thing I want to say is this, because I think it's very important to understand where we've been, where we are, and where we can go. Because I think that often we see that things did not work out fully as we wanted to and fully as the dictates of a piece of paper agreed to by every state say. But we can't be discouraged by that. Because look, human rights promotion always takes longer than you'd like. Always. It's a rule. If it wasn't, we would have gotten rid of torture a long time ago. We haven't. We would have gotten rid of discrimination a long time ago. It says that in the third, elimination of racial discrimination, but it still exists. So these things take longer, and they're about systems, and they're about building on progress, and they're about continuing to take the steps forward to have greater access to justice, to making sure that country after country create the kind of mechanisms dictated by and I think, did I get minutes here? Yes, okay, all right. All right, I'm going to turn to something else because, as you can tell, I might be able to go on and on. Cherokee, I can't help it. We're bred that way. I'll close by saying one thing about where we are at right now, because I think this is very important as we think about the moral imperative, the existential threat of climate change and the moral imperative to address it, raises questions particular to indigenous peoples regarding access to justice, regarding their territories, their lands, and their resources. On the one hand, indigenous peoples are impacted by climate change to a greater degree than many others because we live closer to the land in so many communities. And so the impact on those lands and territories impact us more directly. That's the way it works on something that impacts the environment. And so, of course, the vast majority of indigenous peoples want to address climate change. But at the same time, if it means that it increases mining of indigenous territories and lands for things like lithium, then we need to rethink the way we're doing that, and to ensure, as we're doing that there are processes and access to justice so that their interests are taken into account when creating laws and enforcing laws in how that occurs. Not that it shouldn't occur, we all want to move towards that, but how do we do it in a way better that doesn't impact particular communities as it often is right now? By the same token, and this is also very important, any new industry, whether you're moving from a horticultural society to an industrial society, or an industrial society to an information age, and now the emergence of climate and addressing it to an energy that's cleaner, the greening of economies around the globe, they create economic opportunities too. And heretofore, indigenous peoples have been left out of those economic opportunities. Not that they should be imposed upon them. Again, free, prior, and informed consent. But they should also have access to the economic development that is an aspect of the greening economy. One of the things that I am very happy to see in the United States is that the Biden administration set aside $20 billion specifically for tribal communities to access loan programs so that they can take out the lowest possible interest loans to build things like solar, battery storage, other things that are consistent with that community's values. and that indigenous people's desire to be part of the solution as we move towards a greening economy. So both on the one hand, we have to understand when we're talking about climate, the potential dangers and perils of exploitation of resources that are done in a way that's irresponsible and the impact those things have on the lands, territories, and resources of indigenous peoples. At the same time, we have to be open, our societies have to be open to being inclusive economically to those indigenous peoples, so long it is their desire to participate in that industry. And these are the two sides, and they're not mutually inconsistent. And we should seek both of them. And that is the kind of thing that we need to do as we move forward in making sure that we take the written words of the Declaration and implement them in the real world. Thank you.
Muchísimas gracias. Yo quisiera destacar tres ideas importantes para la discusión que vamos a tener ahora. La primera es la importancia que tiene la Declaración Universal de Derechos Humanos. Estamos 75 años después de esa declaración acá para celebrar porque es un proceso que comenzó
started for the first time with the recognition of rights and the expansions of those rights, and that expansion has been verified with the indigenous people. And so the second one is this access to justice, and we have two very interesting ideas. The first one is that access to justice, the important thing is knowing who decides on what's being decided and where do you decide. And it should be decided in the indigenous territories with the indigenous justice. However, there's a dispute, and we know that the states will not give easily to that. That's why the question is answered with Article number 32 of the Universal Declaration of the Rights of Indigenous People, and that is the previous informed, free consultation process. And another very important thing is this moral imperative that Mr. Harper talked about, which is related with climate change, climate impact. This is directly connected with indigenous people for two reasons. First, they are the ones who are becoming a higher victim on that. And second, because the states need to learn about the valorization that indigenous peoples have on the territories, and not just looking at this as a resource, again, but something that has an intrinsic importance for life and the development of culture. So we have 15 minutes. What I suggest is for us to be able to open up a Q&A session, and then we can, Mr. Harper can answer. Please, to the people that will speak, to be as concrete as possible, so the biggest amount of people can intervene. So we have 15 minutes. Let's try to use them in the most efficient way. So please, if you wish to intervene, comment, suggest, ask, or whatever.
First of all, I'd like to greet everybody who came here later. Well, I'm Isabel Godoy. I was a representative of the Goya people in the last process here in Chile in the Constitutional Convention. And I have been the whole morning paying attention and with awe what has been exposed here, because in Chile these things do not usually happen. Nothing happens what is mentioned here. We had a process, for example, in which we wanted to install indigenous law and legal pluralism. We wanted to leave the Chart of Human Rights as a catalogue which is as complete as possible for indigenous people, but this was regarded like a privilege. So that's how it was given by the rest, or considered by the rest. It was installed by the ultra-right-wing party here in Chile as a privilege for the peoples, because that's what they called us within the convention, the pluralists in a sense. But we've always regarded the importance of the Declaration of Human Rights as the most important catalogue. Nevertheless, here in Chile, it is not respected nor applied. Only Agreement 169, because it's ratified by the Congress. There are no feelings involved. I come from an area, for example, where there is a little village that has 14,000, well, a little city, 14,000 inhabitants, surrounded by 8 mining companies, plus a smelter, which is of the state. There are vineyards as well. First we started monocot farms. Nobody was asked. This was carried out under dictatorship, nevertheless, which has dried out and taken away our water resource. Then the mines installed themselves, and now we have issues with lithium. So if you say that we have given consent for this? No, not at all. This has been imposed on us because here in Chile, consultations are not binding. They are just an errand that the state had to comply with. So listening to these words here, to our brothers and sisters, it truly is incredible how in other countries these things do not happen. Things that happen here in this country, in Chile. And Canadian companies or North American companies are the ones that come here as predators from our territories, of our resources. They have created, they have affected the environments, and we, the peoples, are the ones who have to sacrifice our land, our territories, to solve the issues of climate change. Of course, the less harmful way is possible, but all interventions affect the mother nature. They will affect the salt plains, but we oppose, but they do it anyway, because we are the solution to climate change. Nevertheless, in Europe, they still use hydrocarbons. They haven't stopped using hydrocarbons, and we're the ones who once again have to sacrifice our lands, our territories, to give solutions to something that we have not created. Thank you very much. Dear colleague, please. We request you to be as brief as possible, if that's okay, because more people can give their opinions. We have very little time. We only have 12 minutes to comply with the agenda of this afternoon, please. As brief as possible. In the case of Colombia, 115 native indigenous peoples understand that there is a universal mandate. Once we enter to manage justice or administrate justice, this will not only cover criminal aspects, if not also environmental aspects. Therefore, the universal responsibility on how we have that protection within their own justice systems of these peoples. Nevertheless, this right is within indigenous special rights, so it shelters itself there. So access to justice should have that guarantee also. This is something that we, as indigenous peoples, and within the administration of justice, we recommend the United Nations and the states, its states, to implement the policies and guarantees which would allow an effective and real administration, articulating other systems as well, as many jurisprudence are negative at the moment of administrating justice, or managing justice. Our responsibility, therefore, goes beyond than just a universal right, the rights of peoples, the rights of indigenous peoples. And this system is not just a system of or auxiliary or mandatory justice system, if not its right for dignity, as is established as well in the UNESCO as well, which is World Heritage of Humanity, of course. Thank you very much. There's a question, very brief, please. Very brief and direct, please. Well, I wanted to understand properly here, because what you're saying is something which I want the message to be as clear as possible here. We are, you know perfectly well, you've undergone this process with us, we were colonized where the legal system already is implemented. It was decided by, we have courts and tribunals, we have representatives in certain countries who dictate laws. Those give the rules of the game, right? They dictate the rules of the game. Now, what I understand, and what you're saying, is that many of our brothers and sisters, for example, in the case of Bolivia, for example, who has an indigenous government, they try to set legal structures and frameworks to make possible the defense of our rights. our courts. That's what I'm trying to understand here. Now, in our courts, and not to expect the Inter-American Commission or Inter-American system, even less the UN, because these are systems which are soft law. That's what I understand. And in the case of Inter-American system that we're going to see tomorrow, supposedly there's a court there. There's a court, apparently. Now, what I'm trying to say is that the Universal Declaration of the United Nations, they should work on this since the beginning to try to allow a true access to justice, and so that the courts of justice truly recognize what belongs to us by right for much before the creation of these states. That's the question I wanted to give. Thank you very much. 2 more interventions, and then we'll close this cycle of Q&A, please. Good afternoon, ladies and gentlemen, in my language, Mare, from the Arahuaco Rio Negro tribe. And my question for Mr. Harper is due to something you just said, that the indigenous peoples, we want to become part of the solution. Mr. Harper here, do you think that the resolution of disputes and conflicts could be a fundamental element to eradicate all the issues within our territories? Which would imply to sit down in some technical roundtables together with all the actors and players here, indigenous peoples, governmental players or actors. So therefore eradicate all the mining activities, but also we want to tackle 2 specific issues here. I'm talking about something that we've been going through in Venezuela, the circular economy and comprehensive ecology. Now, what we're saying with the Pope Franciscus about improving our Amazon region, the care of our people, of our Mother Earth, do you believe that that would be a fundamental element to eradicate this issue in our communities? That's it. Thank you. And microphone, please. Quisiera saber el impacto de en la gobernanza local, sí, de la intervención de la... ¿Qué podría considerar usted como un impacto aquí? Well, we got 10 minutes only.
I'll take a very short
Voy a
period of
tomar
time.
ser
So
muy
to
breve.
answer this
Entonces, para responder,
question over here, my suggestion is not that overnight you can build systems to eradicate and make everything right. That is not my suggestion. But my suggestion is that we should understand the UN system, the multilateral system, is a political tool to bring local change. But that local change has to occur in domestically. And it's going to be easier in certain states than others. There's no doubt about that. We all know this. Some states there is the engagement, there is the political will. And all of these things will take much longer than we would like. But I do think focusing on domestic but using the international system as a political tool is the best general approach. And then domestically, what we have done in the United States is try to find opportunities that present themselves to push forward on issues that tribal communities care about. And just finding those opportunities. And whatever the opportunities are, move with those. Don't necessarily wait for what we call a silver bullet in solving all the problems, the panacea. We've seen a lot of really important developments in tribal justice issues. Let me give you a couple of examples. In a case from the 1970s called Oliphant, held that tribal courts do not have jurisdiction, U.S. tribes do not have jurisdiction to criminally prosecute non-Indians, to non-Indigenous. But in the 2013 Violence Against Women Act, that started to change in the Obama administration with the adoption of a law that said tribal courts do have jurisdiction on certain crimes when it's violence against women and girls. And that has allowed for prosecution of non-Indians in tribal courts. And that is to address what is a worldwide epidemic of violence against indigenous women and girls. But certainly it's a problem in the United States as well. We've also seen our tribal courts develop so that claims that arise in on tribal territories, civil claims, often go, it's complicated rules when they go and when they don't, but often go to tribal court. And so those are decided by tribal judges. And so yes, my point is that when it goes to a tribal court, that is a court appointed by a tribal judge under tribal laws, and those tribal laws are derived from the culture, values, interests, and understandings of that tribal community. So it brings an indigenous way of looking at the world. And let me give you one final example. You know, some of the things we see in the wider society, a lot of tribal courts do adopt. I mean, the notion of due process and fundamental fairness in courts, that's a good thing. We should all have due process of law. And so most tribal courts adopt that. But in the Western system, the criminal justice system is almost exclusively punitive. Throw you in jail, put a fine. And a lot of tribal courts, they have adopted what we call restorative justice, which is to bring communities together and not just punish the wrongdoer, but heal the community as a whole by restoring the wrong that occurred. So it's a different and more indigenous way of looking at that. And once you have control of your court systems, then you can implement these different ways of thinking about criminal justice, civil, etc.
Ok, muchísimas gracias. Sé que hay preguntas, sé que hay interrogantes.
Questions here and round tables and everything. So all your questions will be answered soon. So let's organize ourselves with our groups here on our tables, and I give you back the floor. Thank you very much, Mr. Harper, for your time, for your presentation. It's been a huge pleasure, sir. Very interesting how our colleagues have, as our colleagues have mentioned, we're very short of time. Of course, there's much to be said, much to be discussed, but do not forget that we still have, we got tomorrow as well for discussions as well, so hopefully tomorrow will be as productive as today. Very well, so now I believe that we will be closing the virtual broadcast, and now we will go for a debate. We will go back to our tables or our groups regarding the subscriptions that were carried out this morning. We'll have table number 1 here. Group or table 2 will close in yellow, and we will be closing this in the room Lima. 2 will be green in the hall Bogota. So please do not forget that table 1 and 2 will have simultaneous interpreting. Nevertheless, number 3, exclusively in Spanish. I request you all please to... Very well, so the following session in technical sessions will be from now at 4 o'clock until 5 o'clock. From 5 to 5:10 minutes we will have a brief break, a short break for water and coffee, and then we will be back to close the session of today. Thank you very much, ladies and gentlemen, and see you after the technical roundtable session. Thank you very much.
to the speakers of each table to speak about their discussions and findings once the Without further more, please go ahead with the presentations. From table number 1, from table number 2, and the rapporteurs from table number 3, please. Good afternoon. To finish this session that has filled us with many experiences, comments, and ideas and visions that have enriched this very lovely first day, now we will listen the synthesis of the block, the briefing of block number 2, which is territory, resources, rights, and access to justice. As Pedro said, access to justice in the framework of environmental destruction, exploitation and expropriation of lands and resources. So our colleague from Mexico will do a briefing of what was discussed in table number 1. Thank you. So it was clear on behalf of the participant this huge problem that implies the destruction on behalf of the large companies, forestry companies and mining companies especially, among others, dedicated to agriculture of a large scale related to the territory. Even the first intervening, Honduras, with a video conference, indicated that has a huge importance that can cause their disappearance. That is the level of severity of the problem that visualized jointly is shared, of course, by everybody intervening on the table. The government, instead of seeking for these communities to develop themselves through self-government, criminalizes them, as our colleague from Mexico said, and it's a constant with the rest that was heard on behalf of the audience that participated. It was also considered that the businesses are being prioritized with the legal system, through the legal systems, because they are the ones that have direct access to the legal power. And they consider that laws are being carried out, laws that favor them, for them to introduce themselves, following as a mere formality the issue of the consultation process to get that consentment that, even though it's been indicated that it is previous and informed. That is the main criticism performed on behalf of the lecturers. It is just a mere formality. It's just a formality. Now, the issue of self-government in the problem that was indicated here, they are going to disappear by creating criminalizing groups to criminalize 2 or 3 people that spoke with the advocates of the land that have many criminal causes, administrative, so it's a load, and defend themselves through all paths, having as a counterpart sometimes the government. So the load makes them to take a step back or to aggravate themselves instead of going to the next phase. That was somehow the exhortation that was done on following mechanisms of defense on an international level to visualize that problem, since they don't have that level of coercion, but still they don't want to take a step back in the ways that they have visualized this problem from the country. And with the pairs in the different countries, they can force to comply with it. In the rest of the topics related to that main economical power that causes to have just a formality, having human rights recognized internationally and on a state level, one of the speakers was wondering, why is this useful if there are different mechanisms that might be used in order to achieve more effectiveness in the rights? So the answer is that this defense, coordinated defense, it doesn't come from a single part, but from the state or from international organisms and the community itself. Not to give in, continue to fight to keep that integrity in the territory, that defense, that advocacy for the environment. And if they decide on a consultation process, if the answer is yes, to agree with the international laws. What is being asked? Having justice, sensitive justice with informed judges from bottom to top, and not just imposed by those who have a vision on what we might consider good, but from our perspective. It's an issue that was resonating. They said that in Brazil, the judges had a certain level. They even called them of a colonialist origin type of judges. I think that you don't have judges with different social classes, if I can label the problem that was mentioned by one of the colleagues. Perhaps they have this origin, as some said, directly thinking about the community, and through the different efforts they have achieved to scale up to levels of the legal power, not only in indigenous powers, but the one that is imposed by the state. On my side, I don't know if I managed to capture all the essence of the lectures, but it was insisted upon the fact that international organisms should be used, and not just the advocacy of the rights of the communities. And well, that's why we're here. So thank you very much. Thank you very much, Estela. Now we go to the topic talked in table number 2 regarding challenges in the territorial demarcation for access to justice, protection to the right of land, territories, and resources, including the situation of the forced evictions of indigenous people. For that, our colleague Jan Harab from the office from South America will be doing a summary of the topics that were talked about. Thank you very much. In this table, we have the privilege of having 4 complementary perspectives from the legal, judicial power, the parliament, an organization from the United Nations, and the indigenous militants, and from the parliament also, from the perspective of the militancy for indigenous people. And in terms of demarcation, was highlight that the challenges are in several levels. One might be the lack of demarcation. That might be due to several reasons, several factors that make this situation difficult. One of them, obviously, is the lack of political will, the economic power of the different interests that do not favor demarcation of lands and indigenous territories. But others that were highlighted in the presentations were, for instance, the costs of the demarcation processes, costs for the people themselves that might be an important barrier. It was also highlighted that the governments, the authorities in many cases, have little information where the indigenous people live, and due to the lack of information, because of the lack of registries, these activities are overlapped, economical overlapping of these activities in an easier way because of the rule of the strongest one. And finally, one consideration that was repeated in this context was related the collective feature, this collective character of the relation between people and indigenous communities in land versus the Western vision of private property that in some countries maybe the property, the ownership can be protected of an indigenous entity in the south, of an individual feature, but still the tools and the capabilities are missing in order to recognize this in the collective ownership, or maybe not property or ownership, but better yet, a form, the form of the land use connected to the ruling, the governance of the territory itself. Therefore, multiple challenges, and on the other side, some other examples that are quite encouraging, and some elements for a roadmap. Many important sentences were mentioned from the Inter-American Court, and that was quite interesting for us that perhaps are not so related to the Caribbean environment on the Caribbean Court of Justice, and also some instances in which the sentence, the ruling, not only approaches concrete cases, but gives room to a very interesting feeling in the development of the institutionality, protective institutionality in a country, and also the development of public policies. And this was highlighted, of course, and it requires financial resources. This cannot be public policies only in the paper, but budget is also required. In this context was also highlighted something that was mentioned in the previous presentation by Mr. Harper, the importance of conveying whatever is decided on a legal level to real life through a political action in several dimensions of the word, but pressure pressure so the authorities can do what's required, what's needed, because it was also highlighted in this context. Demarcation as such is not necessarily the happy ending of the story. And it was mentioned, very ambitious processes, very successful processes 30 years ago in some countries like Brazil, in which after the demarcation that were remarkable in terms of the size of the territories, demarcated at the beginning of the 90s, that resulted in the last year was a setback. On one side, invasions with illegal entities and also an avalanche of legal processes that wish to weaken the protection of these territories and to allow these several activities, economical activities. And in this sense, of course, the legal judicial power can become a very important protection of the rights of the people of the land, but must be informed with this indigenous vision, whether on behalf of the indigenous justice or maybe by incorporating the indigenous visions in their decision making. Sorry, there are different elements, but I didn't manage to summarize because it was a very truly rich discussion. Just one short comment, which is the fact that it is very important not to consider only the current occupation and permanent occupation of the lands, because many indigenous people used these lands in an intermittent way, therefore should not lose access to them. And we cannot forget about this phenomena of urbanization and the fact that many members of indigenous people leave their territories, but many times it is because of violence, pressure, or negligence from the authorities that do not facilitate life in these territories. Thank you, Jan, for the summary, for the briefing. A big round of applause. A discussion, as it was mentioned, quite productive, quite fruitful, but since we don't have much time, we have limited amount of time, we go to the briefing of the subject approach in Table 3, concerns related to the use of the justice system for the limitation of right to land, territories, and natural resources from indigenous people. So we give the microphone to Darling Garcia from Venezuela, from the Arahuaco people, to make this summary. Good afternoon, everybody. Thank you so much. And well, to be, this is something new to me, being having this rapporteur role. Well, we talked about a very important topic. It is the elephant in the room in the meeting. From there, we're going to have the limitations, the lines that we're going to be working on, the guidelines. So the sister from Guatemala talked about her experience in the strategic litigation, the achievements in her country, her territory, and also incidences in the courts. They have achieved sentences, recovery of the land, and different laws, like the case of the matrons, the midwives. They have managed to achieve this in their communities. And they were talking about how to deal with barriers, how to form indigenous lawyers, how to train them, and to overcome the barriers of the state. I think it's a valuable support performed by the sister from Guatemala. Also working as a team, such as the case of anthropologists, having incidences in public policies. And somehow this has been a new precedent in a strategic level because it's according to the international standards and according to what was said by the sister from Ecuador. It's not only an internal conflict, but also a wider type of conflict, more general type of conflict. The brother from Ecuador was also speaking about his experience in his community on the struggle, the fight of the Ecuador people, the barriers, the limitations. The panelist was saying that they had a barrier, which is the informed previous consultation process, because there were some companies that would establish extractivist projects in their communities and didn't take into account the indigenous authorities. But the previous consultation process was being disrupted. Therefore, they would have to put pressure on the streets with the institutions to execute that constitutional right that emphasizes three things: to get to indigenous authorities, to take them into account, also interculturality and plurinationality. That is in terms of the recovery of the lands. That's why it takes into account the informed previous consultation process. The sister from Chile made a differentiation between the judicial relationship on the territory, how to solve it, the difference between these two terms, how to get to know it, and how to respect it, given her experience here with the indigenous people from Chile, the Mapuche Chilean people, the Mapuche people that collects the rights of indigenous people, spoke about her experience, and now she's part of the second discussion on the reform in Chile. She said that we should not to limit to that, but better yet to continue to work on that. There were some brothers that would ask. We had a brother from Panama that said, well, we indigenous people, we have a vision on the territory on how to face this. We have ordinary instances in the Inter-American Court. And between the facilitators to support for indigenous justice to happen, because it's there. So more has to be done. We need to continue to move forward. Also, our sister made questions such as the restitution of the land, how to face eviction because of the case of the Mapuche brothers. And one of the facilitators said that we need to generate actions. Also take into account the collection of data, take into account the binding tools that have an impact, given that they are still in this process of integration on the system of Mapuche indigenous justice, the legal system. And that is support, a help to finish. And I said, okay, I take a very valuable experience in the Venezuelan case because we are also, as a Mapuche people, in terms of indigenous jurisdiction. We have just managed to for Tijuana and Watuha people, and maybe we can continue to move forward with them. We don't let the judicial power to say but or to put barriers. We are in this path of achieving for the indigenous special jurisdiction, that is how we call it in Venezuela, to be recognized, since we have laws that advocate for us, but we're still there struggling. So I think it's been, well, all panelists and all the supports of each one of the brothers and sisters are very valuable. Each one of them provided their perspectives and their experiences, and they were responded. So without further more, congratulations to all the panelists, especially from table number 3, for that experience that each one of you provided. One of the panelists could not attend face-to-face, but did so virtually, remotely. He was giving some opinions on how the Mapuche people are struggling in order to support and to provide solutions and to become a part of the judicial system together with the constitutional reform. Thank you.
Thank you very much, darling. I'm going to try to summarize everything that has been mentioned on each of these tables or groups, specifically in group number 1. Much was mentioned on how in the destruction of natural resources and the link that exists between the extractive companies and the legitimacy which somehow the states are given through legislations which imply or are translated in criminalization of people, defenders of the land, of the earth, of the environment and territories. Also, the threats in which certain cases would imply even murders of people, defenders of the earth, the territory and the environment. Therefore, we believe it's necessary to set mechanisms which may allow the preservation of the territory, of the land, and therefore avoid that the destructions of the land of indigenous peoples can lead to the destruction, disappearance of indigenous peoples, understanding the cosmovision and the way how they understand the land and this huge bond that exists together with the land and the earth and these communities. So in table number 2, they talked about the challenges in territorial limitations, and there are many challenges here was mentioned, especially limiting boundaries, which some are linked to the lack of political will. Also, there's some interest involved, and also costs, which could imply a limiting or demarcation process. The lack of will from the states which identifies throughout records or registers territories of indigenous peoples, and the lack also of recognition of the collective character of the land and territory, which generally speaking in different states are understood from a Western cosmovision. This issue about private property, which is totally contrary to the idea of collective territory. Also, it has been mentioned that there are many jurisprudences which are pretty important in specific issues in the Inter-American Court of Human Rights, for example, and the courts of Justice of the Caribbean. In table or group number 3, as Darling has just mentioned, they mentioned strategic litigations and incidents at the level of the courts for the recovery of these lands, the sierras, which are the foothills, the mounts and hills, which somehow is observed and limits the access to land and ancestral territories. This has all been fenced, and also has to do with the resettlement that indigenous peoples have suffered due to their lack of knowledge of delimitations or boundaries. So to guarantee in this recognition, therefore, of the right to land and territory, we wish to avoid forced resettlements, so we must continue and advance with a special jurisprudence law, indigenous law. So it's 6 o'clock, 1 minute. Nevertheless, we do understand that time's up. However, if there are any comments, additional comments, maybe we can discuss at any part of this hotel. So first of all, thank you very much for your participation, your attendance, for your ideas and contribution, which of course will together build this line of action, which will be submitted further on. Thank you very much, ladies and gentlemen. And I give the floor to Pedro so he can tell the last words of the day. Thank you very much, Indira. Very well, dear ladies and gentlemen, dear audience also, still resilient here. Thank you very much. So therefore we conclude the day of today, and we are greatly satisfied with the quality and depth of the exchanges and discussions that we have had, the collaboration and the commitment on behalf of everyone have been fundamental to reach a fruitful discussion on the rights of indigenous peoples and access to justice. Thank you very much. Just some reminders. We remind you that tomorrow we will come back. We'll start at 8:30 here in this hall. We invite those who yet have not subscribed themselves in the work teams for tomorrow to please do it tomorrow morning as soon as possible. We hope that you all have an excellent evening and get some rest, so tomorrow we can have more energy tomorrow morning. Thank you very much. And for people who will take the bus to the Ibis Hotel, the coach or the bus is downstairs ready. It's right outside the hotel waiting for you. This vehicle will bring you back tomorrow morning at 8 o'clock in the morning, a.m. And for the all rapporteurs, please submit the reports to our colleagues, once again, to my colleague Rodrigo. And that's enough. That's it. Thank you very much. Have a good evening.